All right, everybody. Robert is not yet here. I don't think he's going to leave me hanging because I can see that he's been active on Twitter very recently. So until he gets here, hold on. Everyone can hear me? Are we in fact live? Let's see. I'm a little delayed because I'm using StreamYard. I think we're live because I hear it on my phone. What's up, everybody? Oh, Robert is here. Good. Okay. Just in time. I'm going to bring him up. Oh, he's smoking a cigar. Hold on.
Oh, yeah.
Good in yourself.
Yeah, that was necessary after that that hearing.
Oh my gosh. Okay, so like, I'm watching it. It's not for political bias that I say this. I can't watch this anymore. This is like the impeachment inquiry hearings 2.0. Nothing new and rehashing the same stuff.
Terrible persuasion. I mean, these are lawyers that are politicians. So you would think they would be some of the best public speakers who had months to prepare just for these hearings. And they're producing some of the most torturous boredom in the history of public presentations.
And you know, the thing about the rules is that they've condensed it into like 24 hours into 2 sessions. That should mean action-packed. That should not mean drawn out, boring, and repetitive. Okay, we're getting ahead of ourselves. Robert, thank you.
Yeah, happy to be here.
This is going to be amazing. So for those of you who don't know, I did a live stream with Robert a few months ago, 2.5 hours. The great thing about that is now we don't need to learn about Robert's life for the first hour. We go straight to business.
Exactly.
And to set this up for anybody, you all know who Robert Barnes is, but Robert Barnes is a world-renowned litigator, attorney in the States, represented Wesley Snipes, Alex Jones, that might get this video flagged already. Who else more recently? The Covington kids. Who else that people would know about that you've represented?
Probably the other most famous one would be Ralph Nader.
Ralph Nader. And we talked about that in the previous live stream. I've warned. I DM'd Robert before this and I said, we're going to touch on 2 subjects. Everyone needs to get a little follow-up in the Nicholas Sandmann suit. And then we're going to do the impeachment hearing. What I told Robert, I would tell everybody, Robert still is the active attorney for the Covington kids in that lawsuit. There are certain things he cannot say. And so I'm going to respect that in the questions I ask, because some questions I ask can even imply knowledge, even if the answer is no. Like if I say, do you know something? And if the answer is no or yes, that might already convey information that he's not allowed to convey. So with that said, I'm going to answer all super chat questions. And if I don't see one, harass me, make sure I get to it. We're going to take as many questions as possible. I figure we should start with the one that's going to be the shorter of the subjects, a Sandmann follow-up or the Covington Catholic kids follow-up. Do you think we can do that?
Sure. Yeah. So so Nick Sandmann is represented by Lynn Wood and a local lawyer in Kentucky, who apparently is now running for Congress. That's another story for another subject, for another day. And he did obtain a successful settlement from CNN. The terms of that settlement were not disclosed. I don't have direct access to the terms of that settlement. I have, some inferential guesses as to what that settlement was, but they would just be speculative guesses at this juncture. And there's been public speculation of a very large settlement amount. There's been other speculation by lawyers of a much smaller settlement amount. Bottom line is we will likely never know what that amount of settlement was because they agreed to keep its financial terms and all other terms confidential. And so that's where the Sandmann settlement status is. There was a brief public controversy because some of Sandmann's lawyers have for whatever reason, we occasionally have had differences of strategy and differences of opinion about how to proceed in the case. My clients are focused on getting public remedy that will deter bad conduct in the future. They are not interested in private confidential settlements. So there's just a different strategy between us. And I respect their strategy, and they have come to respect our strategy. And so but in the interim, they have occasionally flared up various public controversies or disputes or disagreements, which is unfortunate. I've tried to tamp down and not respond or get involved in a lot of that. A lot of it is because the local lawyer representing Sandmann is challenging the Republican incumbent there in Covington. A lot of the people that I'm connected to back that incumbent. I'm trying to avoid getting involved in that as well. I'm not a huge fan of lawyers running for office in the middle of a suit, but hey, that's their prerogative. That's his choice.
That's very
But because of it, you have all these sideshows that are unnecessary distractions. But so that's the update on the Sandmann side of the equation. On the other side of the equation, the Covington kids, our suits are currently pending. There's 8 motions to dismiss pending before the Kentucky State Court. We are filing our responses to that in February, and the oral argument has now been scheduled for March the 5th in Covington, and I will be there for that hearing, along with the long line of defense lawyers, which include some of the top media lawyers in the country that have come to the defense on the other side. In addition, next week, we will be filing our, in fact, I've been working on it all this week, our brief before the Sixth Circuit Court of Appeals on whether or not the congressional immunity immunizes all senator or congressional speech while they are a member of Congress or the Senate, no matter how tangential it might be to their legislative activities. This will be the first such case in the Sixth Circuit. I think you've vlogged on it. There are a good number of commentators who sort of share your sentiments that we have an uphill battle. That's not uncommon for most of the cases that I take. On paper, at least, they usually are uphill. But I think we might have just enough to get over the hill and succeed, but we'll find out. It's an important case, and it's a case that, on that part of the case, I believe ultimately will go to the U.S. Supreme Court, because they have not addressed whether or not the congressional immunity statute expands the definition of immunity beyond the speech and debate clause, where they said in prior decisions that it does not extend outside of legislative tasks and activities. So I think it's a very important case that has very important consequence, where even if we don't prevail in the courts, I think the public will be shocked to discover that Congress is now asserting this broad immunity, and it might lead to necessary legislative change. So there's multiple ways to get the desired remedy in the end.
Okay, so that's very interesting. And we're going to back that up a little bit and break it up into several parts. Going right to the beginning, Sandmann settlement, not public information at all. There was what we know from, despite not being public, was that there was no public apology, retraction, or CNN announcing change in policy. But we don't know of any other terms other than what was not done, which could have otherwise been in the settlement. No quantum. Everyone's hypothesizing. I don't know if you know Mike Cernovich. He did a live stream, hypothesized anywhere between 750,000 and 2.1 million. I've made my prediction, which we may or may not ever know, of anywhere between 5 and 20, which might be very optimistic. People are hypothesizing 250. Some are hypothesizing less. We don't know. The flare-up between you, and now that's very interesting because I didn't know about the political background or the political backdrop to the disagreement, but I did notice on Twitter, there was, it's McMurdy, right? Who's one of the attorneys for Sandmann?
Yes, that's correct. Todd McMurdy.
Todd McMurdy. I noticed them tweeting with Sandmann and Lynn Wood saying things that I wouldn't necessarily say in written word, that they don't want to have to file proceedings or file ethical complaints, but you don't represent Sandmann, which there was no ambiguity for me ever, but maybe because you clarified it on our stream. And I think they were taking issue to it because why were they taking issue to it? Why were they even thinking that you were purporting to represent Sandmann?
You know, what they did is they saw public coverage about the other Covington kids' suits, and I think misconstrued some of the stories. And the reporters in those stories quickly told them that I had been crystal clear that I don't represent Sandmann. There's always going to be some public confusion. So there's people that attribute both good and bad aspects of the Sandmann litigation as they perceive it to me. And so I repeatedly explained, that's not my suits, that's not my style, that's not my strategy. Nothing about that really reflects my approach or my client's approach, which is it's a different approach. I'll leave it at that.
I've noticed whenever you refer to it in public, you refer to representing the Covington kids. And exactly. I think people are confusing Sandmann as being the face of the Covington kids versus you representing the other Covington kids who are unnamed.
Correct. And what I tried to repeatedly explain is all of my clients are anonymous. So by definition, Nick Sandmann isn't one of them. And so he's decided to out himself. He took a very different approach to all of this, which was, again, his prerogative. To all the people that were in the press, all of them were a little startled by a lot of that activity, because they all knew I had been very clear on multiple occasions as to who I did and did not represent. In fact, there's other Covington kids also being represented anonymously by other lawyers in other pending potential legal actions. I think in some cases they filed, in some cases they've simply, told me about it and asked for my feedback and advice. But so because you had about 40 different sets of kids that were impacted by this in one way, shape, or form, about 20 or so were shown in the photos. I represent 10 of them. 9 of them are moving forward with current litigation. 1 may down the road. And then Nick Sandmann is the famous one just because he publicly disclosed his own name primarily. And so I think from some of their perspectives, they think any Covington suit somehow involves Sandmann. And there's always going to be some public perception of that. You can't make sure everybody knows exactly the proceeding. Yeah, but I've never cared one way or the other about it.
No, and you have to take for granted a certain level of self-education, which may or may not come, and people will make whatever false assumptions they're going to make. Very quickly, I'm going to address some super chats. Rainy7, thank you very much. Is it true that Canada has outlawed the penny and that you should be fined in attempting to present one at an establishment that serves poutine? In Canada, we have done away with the penny, so we round down or up, but no fines for attempting to do that. There were 2. I need to get all these before we get too late. Okay, here we go. Saki Onse, Mr. Barnes, glad to hear you. Do you think the defense of the impeachment is going to be a grand event? Sorry. Or will it be short without witnesses? Do you think Adam Schiff is possessed? Look at it. Okay, we'll get to this one in a second. Undoubtedly, Sakaki, thank you very much. We're going to get into the impeachment soon enough. And if we don't answer that question, remind us by the end of this. And we got Will Carter. Question for Mr. Barnes. Does he think it is plausible or probable in his most private speculative of hearts that CNN settled primarily or partially in order to prevent discovery? We're on the subject. This is a good one. What do you think?
That's always possible. I mean, I think probably the primary motivation for CNN to settle was the public embarrassment to their credibility, because they like to perceive themselves more so than MSNBC and some other more liberal, overtly liberal networks. They like to perceive themselves still as an objective, neutral network. So the Sandmann coverage and coverage of the suit was publicly embarrassing to them. Now, from my client's perspective, what we had requested of CNN, they mostly did. They issued corrections. They put a front page story and made it a headline story throughout all of CNN that, in fact, the kids had been cleared by an independent investigation of any misconduct. And that was our objective, was to get CNN to print that correction. Now, they could have gone further and printed more corrections, but once Sandmann sued, we just sort of stepped back from that aspect and focused on individuals rather than institutions, where I think real change can take place on a go-forward basis. But there's always a possibility in any discovery, in any defamation suit. Discovery can be both an expensive proposition from a defense perspective. I mean, you can easily spend hundreds of thousands or even millions of dollars in defense of a litigation just by the discovery part of the case. And I'm sure there was some internally embarrassing emails and communications and texts that they didn't want out there. I suspect people like Jake Tapper, once he figured out he'd been hoodwinked and he publicly retracted and corrected, probably made statements like that to other people, probably did it by text, probably did it by writing, probably out there in order to look bad for those other people that they didn't follow up on the corrections and retractions in the same vein. So I think that there would have been a lot of embarrassing information. I don't think it's necessary. Like some people think maybe it would reveal conspiratorial intent or something really bad. I don't think that's likely. There's always a possibility. But I think it's more just for CNN's reputational interest. This suit going forward and the discovery that would have been unveiled would have been institutionally embarrassing to their public desire to be perceived as an objective, independent, nonpartisan media source.
Very interesting. Yeah, there were, first of all, Will Carter, thank you very much. There was some speculation where I was in the comment section of my video addressing the settlement. People say, yeah, they avoid discovery. There might have been embarrassing correspondence. We know what the internal correspondence probably looked like. And then other people were suggesting maybe it would involve government officials, some sort of collusion, some sort of coordination. And, that's where you get into stuff that you can never really prove or you'll never really know. But
I mean, we'll probably know because I have sued Reza Aslan. Now, it may be the case that Sandmann's lawyers pick up the Aslan suit and move forward. That would be fine by me. I sued him because they had not, and that was probably part of the source of the controversy on that subject. But Aslan's, what they didn't realize fully was Aslan's comments, while they were specific to Sandmann, were general within a variety of tweets that were interpreted as a green light of violence against everybody. So my clients received direct threats that were in response to Aslan's green light of violence against the Covington kids writ large. Nobody saw his tweet and thought, oh, only Nick Sandmann should be attacked now. That's what was wrong. The account that purported to be Nick Sandmann's account, I'm not sure that it actually is, but was making comments about legal theories in that regard. They were just unaware and uninformed that, in fact, other people had been threatened based on Reza Aslan's tweet. Now, Reza Aslan has previously been employed by CNN for an extended time period, so there's aspects of communications that may be unveiled in that context. Same with Kathy Griffin. Same with some other people that we're suing, Maggie Haberman of the New York Times. Of course, obviously, the political lawsuits involving the politicians, Senator Warren and Congresswoman Haaland, that discovery would get much closer to revealing whether or not there was government official collusion with some members of the media to slander these kids and then to try to cover up the scope and scale of that slander afterwards. If there's discovery anywhere to that effect, that's where it's more likely to be.
Okay, very interesting. And before I get there, Reza Aslan, last tweet that he said was he didn't know who you were. He hadn't been served. Does he know who you are, and has he been served now?
Well, I know that, put it this way, within the same time frame, within 24 hours of our service processor locating him and getting word that we were trying to serve him, which most people who are someone's trying to serve them, you get word of it. He suddenly decided to delete the tweet. So I was glad he did, and I publicly thanked him for it. But he pretended that he was like, I don't know. No, the lawsuit had nothing to do with it. It was just my wife suddenly persuaded me after all this time that I shouldn't have done this. So, I'm glad he took it down. It's good for my clients that he took it down. It should not be there. It's dangerous and threatening to them on an ongoing basis. So I'm glad he did it. I don't really care why he did it. But I suspect the service processor trying to find him and locate him might have had something to do with it, given the timing of when he did it.
Okay, very interesting. Very interesting. Now, with one more super chat here is Stephen Britz. In the current clown world that we are living in, is there any hope of using the law to get back some sort of sanity, or all is lost? I've been pessimistic these days. We're the lawyers that we're seeing on the forefront of the national scene are not necessarily working to get things into a more sane environment. But Robert, maybe you're more of an optimist than me.
The way I put it is we are at the cutting edge of a wide range of cases, including, in my view, as we'll get to, the impeachment case that can potentially be used for a very positive moving forward precedent. So I think a lot of these defamation cases involving the individuals with Covington could have a very salutary effect. I think it already has to some degree. I think you've seen at least some more hesitance among some part of the individual members of the press, particularly those that have been sued, but I think some others too, to be more careful about the kind of statements they make about individuals they don't know. I mean, even someone like Congressman Omar, who has not been restrained in some of the things that she has stated, has stayed away from saying publicly false things about private individuals ever since I had threatened her with suit in the Covington case, where she retracted and deleted within an hour of the roll call story being written about it. So I think the law can yet still be used for good. It's just always been an uphill battle, and it's been an uphill battle for 200 plus years, because those who wish to use it for ill tend to have more power than those who wish to use it for good.
Well said. And this brings us into the motions to dismiss, congressional immunity, and potential legislative solutions if the public gets shocked enough. Sorry, my computer's shaking. So the Elizabeth Warren suit and the who is the other politician? I forget her name now.
Congresswoman Haaland from New Mexico.
Yeah. So those two suits were dismissed on the basis of sovereign immunity. The idea being that whenever any elected official or government official, public official does or tweets anything or says anything in the context of their employment, they benefit from immunity. And now the motion was dismissed. The lawsuit against them was dismissed. You're appealing that decision to the Sixth Circuit?
Yes.
And that's going to come up when?
So we file our brief next Monday, the 27th. Then they will file their response before the end of February. We'll file a reply brief in March. The Sixth Circuit Court of Appeals, given its recent history of scheduling, is likely to calendar oral arguments sometime in the late spring or early summer. And then the Sixth Circuit will likely make a decision before the year is out. Then if the case goes up to the U.S. Supreme Court, and I think either side will take it up. Whoever's not on the winning side is going to run it up to the Supremes. And I think this has a much, the current Supreme Court acceptance rate is 1%. I currently have 3 petitions pending before the U.S. Supreme Court, so I'm intimately aware of those odds. But I think this has an unusually high chance of getting up there, because it's such a high-profile case, because this issue has never been dealt with, because it's a pure question of law before the Supreme Court. I think we have an excellent chance to get there. I think if our side prevails in the Supreme Court, that would be great. I think it will stay that way. But I think if the other side prevails, we will have a very good argument to Congress that they should not be writing laws, making election to Congress a license to lie and libel about your friends, family, and neighbors. And I think the public will be slightly shocked that even exists, the scale and scope of it. And so I think there'll be some public outcry for change. And I think we'll probably get legislation that will change. So I think either way, the remedy that is sought here to prevent politicians from lying about private citizens in the future about matters that don't concern pending legislation will be achieved. It's just what manner and method by which it's achieved.
And it's amazing, because everybody should appreciate that, is that the lawsuit was dismissed on the basis of sovereign immunity. Warren and Haberman, I'm going to mess up your name, sorry, could tweet and they could tweet, say whatever they say. If they did it in their official capacity, they were immune from lawsuits or damages as a result. It's going to go to appeal. You're going to be heard hopefully by end of spring, summer, before the end of the year. Presumably, what I'm understanding is if you lose in appeal, you're going to petition the Supreme Court.
Yes.
What I would take for granted is that if Elizabeth Warren's side loses and that the action is reinstated, they're going to take it to the Supreme Court. One way or another, it's probably going to go to the Supreme Court. If it's going to be heard, we'll see. But I can tell you from the comments section on my video on that subject, whoever didn't know about sovereign immunity learned about it, and they were in fact shocked. They were like, Elizabeth Warren runs around saying nobody's above the law, people should be responsible for their tweets, and then lo and behold, when it's time to hold someone responsible for their tweets, suddenly they're either above the law or the law is grossly in their favor, where they are immune from the consequences of their actions, and people were shocked. So it is a very interesting thing that win or lose, however long it takes, the public outrage will probably be sufficient to warrant legislation, or whoever's going to run for office at that point, it's going to run on a basis of, we might introduce this as our first piece of signature legislation, that the immunity was only intended for debates on legislation and when you're in Congress, and not when you're outside tweeting on your cell phone.
Exactly. And I think that because there were people early on who were publicly critical of me for suggesting the suit. Even they went on Fox News and other places and said, oh, you can't sue a congressman. We don't know what Barnes is talking about. And I was aware of the law, intimately aware of the law. And my view was, well, the only way you get this law reversed is by challenging it through the court system, because either I'm right and the law shouldn't be expansively interpreted this far, or if it is really interpreted this far, then the public needs to know about it because they won't approve it, and that'll put pressure on Congress to ultimately change it. The way you don't change the law is sitting and saying, well, golly gee, I probably can't win, so I might as well just sit down and not do any work on it. I've never found that a successful method to make change in the world.
No, and it's phenomenal. And it's sort of, not to say I'm contributing to anything. It's not really my ultimate objective, but if I can do it, all the better. But making that vlog just explaining the dismissal, it shocked people who would have otherwise never even heard of it. But for that video, they would have certainly never heard of it, but for your lawsuit to get there in the first place. And it's not like mainstream media is rushing to cover that lawsuit, because it doesn't exactly make someone who's running for president look all that good in her conduct and in her defenses to her conduct. So awareness, and sunlight's the greatest disinfectant. Awareness is one step in the right direction. And right now I just have to thank BB. Thank you very much. Love this. This is fun. This is good. Okay, so that's good. I mean, I don't think there's anything more that we can do in the Sandmann cases. In the Sandmann case, I mean, it's interesting. People are still going to hypothesize forever as to the quantum of the settlement. It's good. It's interesting to have the background of what might explain the the inter-attorney quibble, but there's certainly strategic differences. I mean, anybody can see the strategic differences in lawsuits, and that you're suing for 35 to 55,000 per defendant and not 250 million. So one can imagine that there are fundamental differences in ideologies of the suit and the purpose of the suit. So it's interesting to know. Okay, before we move on from Sandmann into the impeachment, because I think that's what most people are getting either obsessed with or fatigued with. If anybody has any more questions, drop them down there, and I'll see if I can spot them before we move on. Nothing else in the Covington.
Not really. I mean, what's fascinating about it is what I told people, it's going to make all kinds of new law. So important law about what congressional immunity is. It's going to be important law about personal jurisdiction. Can you get away with defaming someone and saying, well, that court system can never hold me responsible because I made my statement on the internet? It's going to make new law about what is defamation. Can you say certain things by indirect reference without specific reference and thereby get away with it? So there's a whole bunch of unprecedented areas of law. Is doxing an actionable tort under invasion of privacy claims or intentional infliction of emotional distress claims? All of these have never been litigated for the most part. So we're going to be making all new important law. Hopefully that will benefit a wide range of people so the press understands they can be held accountable when they lead a social media lynch mob against a bunch of kids.
Yeah, well, I mean that's it. If doxing is not sanctionable under whatever existing law there is, it will be sooner than later, because that's something that I think people are they're in what's the word, unanimity on the offensive and shocking nature and the devastating effects of doxing. So that I think, there'll be some movement on that. It is very interesting. Like in 50 years' time, this might be the Sullivan versus New York Times of 1965, depending on the impact. It's very cool. Very cool.
Absolutely, that's the objective.
Okay, well, we'll be following it as if there's any ever developments. Well, everyone knows that I know you now, so I can get not some insider info, but I can get some up to date info.
Absolutely.
And it seems that YouTube has not been notifying people of the stream, but whatever, we're doing good. Okay, Robert, the impeachment. Now let's preface this because anybody's going to say it, and so we should just address it up front. I follow you on Twitter. You are, I would say, an unabashed Trump supporter, or at least a vocal critic of the impeachment process.
Definitely a vocal critic of the impeachment process. I would say I'm on the populist line of thought, which is not very common amongst American legal professional class types. But that's an old school tradition for me. Been that way since I was a knee high to a grasshopper, as they say in Tennessee. I was opposed to the Clinton impeachment. I'm an old school rule of law guy. So, Dershowitz, I usually agree with Dershowitz 95% of the time. I probably wouldn't have represented Jeffrey Epstein, but beyond that, I agree with him almost all the time. Because he's an old school rule of law guy. So he recognizes that things like impeachment, whatever legal precedents we set in that context, are going to be repeated in the past and ultimately are going to endanger everybody if they're not carefully constrained and constitutionally constricted. And so I would have this, even if this was Obama being impeached, or even though I kind of liked Obama, even if it was someone I politically really disliked, if it was Hillary Clinton being impeached, I would have the exact same opinions if this was the nature of the impeachment, where they were not charging crimes, where they were not developing evidence in a fair way, where they were using almost every impermissible method of evidentiary presentation in their opening statements. So on the substantive side, I would have problems all the way through. On the stylistic side, I'm going to use this as an example for interns and associates who work for me to show you how not to argue to any audience, because they are just failing almost every test of persuasion. I mean, this was a beautiful opportunity for them. They had a very susceptible audience. I mean, there was at least half a dozen Republican senators who have a known historic hostility to Trump, disagree with him on particularly the set of policies involving Ukraine and foreign policy in general, and who just dislike him personally. And so they could have got them to rule in their favor on a lot of preliminary motions and on future motions, which they still may succeed at, but for the tactics and techniques they've employed. They're people that have grown too accustomed talking to each other and on Rachel Maddow and don't understand how they're coming across at all. A very poor sense of self-reflection and understanding, and just bad stylistic mechanisms of presenting. None of these people would pass for good lawyers in an actual court.
Well, so I mean, and that we'll get into that event. I mean, probably sooner than later with Justice Roberts admonishing both parties yesterday, and I saw the highlights and I saw the admonishment, and I couldn't disagree with the admonishment from one side or the other. So now I'll reframe that, because whenever anybody is deemed to be biased or partial, and they say, "Well, I would have reacted the same way had it been my political adversary who would be in the same shoes," people take it with a grain of salt. So I expect anybody who is going to take that, what you just said, with a grain of salt, to take it with a grain of salt. I think the same thing as well, is that personally, I have no favorites and I have no picks, but I've been following this closely. And if this is going to be the new standard, then I can see how governments fall and societies fall in short order, clearly. Let's back it up to one fundamental question. It's one that Dershowitz disagrees with himself 20 years prior on, the core issue of the impeachment, and that is the question of whether or not the impeachable offense has to be a criminal offense.
Correct. And I think what's fascinating to me is the Scholastic Academy has been out of touch with this for a long time. So you're most of your average everyday lawyers and legal scholars will say, "Oh no, it doesn't have to be a crime." And that's because it's something that the post-Nixon impeachment sort of instructed a lot of law professors into believing. And it became sort of a cultural truth that just was not a historical truth. So, I mean, like what startled me was, I was like, any skilled lawyer, the first thing you would do is go look back to past precedents and past examples. And in the context of impeachment, that just happens to be past Senate trials. They're not in court proceedings. And here we have great examples. The first big impeachment was the impeachment of Justice Samuel Chase in 1805. And there you can read the actual transcripts. They're mostly transcripts. What it is back then is there was a journal taking notes, where the word journalist comes from, someone in a journal taking a journal of events. But it's very well detailed and almost like a transcript, and sometimes is transcript oriented in what it wrote down. And we have great transcripts from them listening to both sides argue in 1805 what constituted an impeachable offense. Then we have another example with Andrew Johnson in 1868. And then we have, people forget the Nixon impeachment never reached trial stage, so whether it was validated or vindicated was never decided. And then we have the Clinton impeachment of 1998, the four sort of a quartet of infamous impeachments, three of which reached a Senate trial stage. What all those Senate trials have in common is that the senators actually in each trial, when they were asked, rejected the definition of high crimes as being anything other than something that was a crime. So, for example, there's a variety of people like Lindsey Graham when he was a congressman, Alan Dershowitz in 1998, who didn't think a crime was required because that was sort of the conditional norm of the Scholastic Academy. But that was contrary to, first of all, the plain language of what the actual text in the Constitution says. Also, the entire structure of the Constitution that seems to presume, in reference to impeachment, the existence of a criminal offense underlying it. But it also contradicts every Supreme Court justice who's ever argued on the Senate floor, prominent founding fathers and future senators who argued on the Senate floor, dating back to 1805. And implicitly, the senators' votes in those impeachment trials reject the idea that anything but a crime can be the basis of presidential impeachment. Now, the idea is that the crime has to reach a level that it's so serious it's threatening to the republic, like treason, like bribery, akin to it. And that's where Dershowitz has said, I always thought it had to be something significant, but I didn't realize the scope to which it was always supposed to be criminal until I went back and read Supreme Court Curtis's opinion in 1868. That may have been in part because of me. I've been harassing Dershowitz for about 2 weeks with that. So because I wanted this, I was shocked that all these people are talking about this and not one of them are talking about actual impeachment histories where actual justices made arguments at the time about what it meant. I mean, the 1805 impeachment would be the most persuasive to me if I was arguing to the Senate. It's also a great precedent of how to argue to the Senate, because these were successful impeachment arguments, because in both of those cases, the Senate had enough votes on the political opposite side of the person being impeached, unlike this one. And yet in both cases, they persuaded people to go against their own party and vote against impeachment because they were offended by the constitutional implications of what it meant based on the effective persuasion of the arguments made. People want to see what real arguments look like as opposed to these sad, pitiful examples of it that we're seeing from so far from the Democratic House managers, at least. Go back and read the Justice Chase impeachment. Go back and read the trial transcript of Andrew Johnson's impeachment, where, I mean, Justice Curtis literally hated Andrew Johnson. I mean, hated him with an unbridled passion. Came from the opposite side of him politically. A recent Harvard Law Review article said Justice Curtis coming to the defense of Andrew Johnson would be like Justice Ginsburg resigning from the Supreme Court and coming to the bench of Donald Trump. That's how dramatic Curtis's defense was. So Curtis, he's like Dershowitz in this respect. Dershowitz has defended Trump a lot, but there's still not a lot of doubt that Dershowitz didn't vote for him in 2016 and is probably not going to vote for him in 2020. Dershowitz knew he's going to take tons of crap for defending Trump on the floor. But I have no doubt really that this is exactly what Dershowitz believes. He's just the kind of guy to advocate for someone if he thinks they're in the right on the law, even if he doesn't like them personally or doesn't like them politically.
Okay, it's very interesting. Because now this is going to go back to something. I don't know if you know who Legal Eagle is. He's another YouTube lawyer. If one had to qualify him politically, I think they would put him on the left. And his spin is typically left spin. And I say that with respect because he might be right on the law, but his interpretation is slanted. So it says, didn't we get Legal Eagle doing a historical look at high crimes and misdemeanors being drafted into the Constitution was based on English law, which was not specifically law crime. So the argument, as I understood it, was that it's bribery, treason, or other high crimes and misdemeanors. So the argument that I had been reading in various places was by referring to it as high crimes and misdemeanors as opposed to other crime, or as opposed to crimes, is that the other and the high crimes qualified the crime to include stuff that is not necessarily a crime but could qualify as a high crime if it was sufficiently serious but not necessarily a crime. So
this exact argument was made in 1805. So in my view, the better of the argument that was made at that time by Justice Chase actually argued on his own behalf. In addition to that, Judge Hopkinson, who was the son of the famous signer of the Declaration of Independence, Francis Hopkinson, came in and he was an active judge, came in and defended Justice Chase on the Senate floor. In addition, Luther Martin, who was actually at the Constitutional Convention, one of the founding fathers, came and defended him, and future Senator Robert Harper did it as well. And what they all argued was, though they took different parts of the arguments, highlighted and accented different components of the argument, a lot better than this Democratic group is doing in terms of dividing up the labor, not repeating and duplicating the labor. They made this exact point that the high crime had to define misdemeanor, and that what was meant by that was it had to not just be a crime, but a crime equivalent to something that threatened the very existence of the republic. Otherwise, that Madison's protestation at the convention, which was because the English law include a version of maladministration as a basis of impeachment. Mm-hmm. And there was an existing impeachment at the time of the Constitutional Convention going on in England where they had included non-criminal activity as the basis for it. And one of the senators said, I want this to be included. I want something like maladministration, particularly said, you can imagine all these abuses of power. So we'll just call all abuses of power maladministration. All of us, Madison objected. He said, then all of a sudden the president just serves at the pleasure of the Senate. And he goes, that makes all of a sudden we have a parliamentary democracy all over again. There's no point in electing a president if the president can be removed anytime the Senate disagrees with him with something as vague and nebulous as maladministration. And that's why it was struck from the Constitution. And so we went further and beyond what the English Constitution required, what the English laws required. Now, what's complicated is the definition of a crime has changed. So back then we had common law crimes. Now we are only allowed in the United States to prosecute crimes federally that are statutory in orientation. But that change should not change what the purpose or principle of that plain language of the text means, which does say high crime and misdemeanor. And so I always find it peculiar when people are like, well, it says treason, bribery, or other high crimes and misdemeanors, but that doesn't mean a crime. I'm like, well, if that was in any other text, we wouldn't accept that as a definition or interpretation of a statute. It's contrary to the plain language of it. And then we look at the rest of the Constitution. Why is there a provision for not being able to pardon someone who's impeached? unless they're presuming some degree of constitutional some sort of criminal charge is the basis of it. The language actually interesting that was used was not so much criminal law language, because you had this common law, old historical antecedent in the past. It was, if it's not indictable, it's not impeachable. And that was the words of everybody who argued on the Senate. And interestingly enough, in 1805, the counterpoint was not that it had to be a crime. The counterpoint was a rather peculiar argument when we look at it historically, but it was, impeachment was meant to cover things that were not criminal. If they were actually criminal, then we would indict and not impeach. And that argument was taken apart piece by piece by piece in 1805, such that they didn't have much credibility at the end. And it's why they lost a lot of the politically aligned senators by the end of the trial, and Chase was acquitted. He was acquitted by a majority vote on 10 of the 11 accounts, and on a close vote on the last one. And that was the one that came the closest to being criminal, because it was a quasi-obstruction kind of charge. But so that's where, and then the same argument, 1868. Justice Curtis within the first minute of his opening statement, says if it's not indictable, it's not impeachable. And he explained the other reasons for that, aside from the plain text of the Constitution, its history, the whole structure of the Constitution, the necessary separation of powers that are implicated if, in fact, we don't have this limitation on the definition of impeachment. But he argued the ex post facto laws, the Bill of Attainder provisions, and the Due Process Clause all require that we have a clear definition of what it is you can be impeached for. The way Judge Hopkinson put it in 1805, he said it's equivalent. He said, if we don't have clear definitions of what's impeachable, and that clear definition isn't known to the person in advance, so they know the scope of where they're allowed and not allowed to behave, they're looking at something that they think is concrete and is going to turn out to be quicksand. And it was a very persuasive argument, repeated again in 1868, actually repeated by several of the Democrats in 1998. Their point was a little different, because Clinton was in fact charged with crimes. Their point is it wasn't a high enough crime, it was a personal crime, not a public office crime.
No, and it's amazing, because now that you explain it like this, it's sort of, one can understand now high crimes as misdemeanors, not lowering the threshold below an actual crime with the high crime, but rather raising it above, let's just say hypothetically, a simple battery charge. Like the president gets angry and slaps the vice president and is charged with battery. Well, that's technically a crime, battery or assault, whatever you want to go with, but not sufficient to warrant impeachment. That's why they refer to the crime has to be a high crime, such as sedition or murder. I don't know, something that's fundamentally incompatible with the office, as opposed to something that is only incidentally, or call it a soft crime, so to speak.
Exactly. To give an example of that, the original language was a high crime or misdemeanor against the United States. And in the grammatical, they had an editing board, they just took out against the United States, because they thought it was already clear that high crime and misdemeanor meant something that was like treason and like bribery, because of the language. Because they could have said treason, bribery, or high crimes or misdemeanors. But instead they said treason, bribery, or other high crimes and misdemeanors, and that they were interpreting it at the time as like treason, like bribery. Like treason and bribery are both crimes, but sufficiently serious as relates to the presidency or elected officials that they are high crimes. So treason, bribery, or other similarly high crimes and misdemeanors. Okay, I don't want to say that I'm convinced, and now I think that I've been wrong in the previous videos where I've said what I thought I understood as being, if they don't like his underwear, they can indict him, because it makes sense where you say, the rationale that I had in my head was, okay, if the president is so fundamentally loathed by both the House and the Senate that they both want to, that it's just, it makes governance impossible, then impeachment, it makes sense as a political tool. But when you explain it, then you just have what was the word? What's the word for that type of government? You used it earlier. A parliamentary government.
Parliamentary government. Yeah, well, then you just have, it's not the people that elect. The people can elect him, but the Senate and the House, if he's too much of an outsider, can say, get him out of here, and we'll have them elect somebody else who we like.
Exactly. And part of the historical basis of all this was there were several of the people at the convention that were opposed to any impeachment power at all in Congress. They were like, look, if there's a problem with him, the people can take care of him at the election. That's what our 4-year term is for. And the counter argument was, well, what if he so co-opts the power of government that he makes it impossible for an actual election to occur? And they said, that's when we have to have some means of removing him. when he's actually using the power of government to shut down and suppress government, like a president who's sold out his government to a foreign nation, a president who's taking bribes and exchanging political authority for bribes, a president who's, say, acting the militia and saying we're going to shut down half of the voting boxes in America. They said we need that remedy, and they're like, okay, well that would be treason, that would be bribery, and somebody said, well there could be more examples than treason or bribery, and that's where the debate came up with, well, let's include maladministration, and they said, whoa, no, that's too vague, too obscure. We want something that's like treason or bribery, and they're like, oh, okay, other high crimes and misdemeanors against the United States. And that's why that argument, like when you read the transcript of the 1805 impeachment trial, which I'll send you a link so that people can see it in the link below and look for it to themselves. Not that they necessarily want to, but it is great reading. You get to see old school, great scholastic arguments and real rhetoric, rhetoric like this is the language of the old Roman tyrant and so on and so forth, and the evils of the ancient world. They're doing that kind of stuff. Some old, like people who are clearly trained on Cicero and Latin. And like our old lawyers were. And so and you see it then. In that context, their arguments, when I read it, it was so much more persuasive. Because when I first looked at this, which was actually all the way back to the Clinton impeachment, because I was in law school at the time, I had the same assumption. All my law professors were like, oh, no, you can indict for anything as long as it's, reasonably serious. You can impeach on that basis, even if it's not an indictable crime. And so I listened to some of the Democratic arguments, which were, well, it has to be a serious enough crime. And then in researching it, I was like, well, we might as well start at the beginning. Let's look at what the original people thought at the time or close to it. And when I read it, I was like, their arguments are so much more persuasive than what my own law professors are telling me, that it just made much more sense. And also particularly from a due process and little d democratic perspective. It's about, let's trust the public to make the decision. Let's trust the people to decide wherever and whenever we can. That's sort of the populist within me. But there was a large part of the constitutional founders that were of the same vein. A lot of my great-great-grandfathers voted against the original Constitution because it didn't include the Bill of Rights. They were Rhode Islanders. Well, then the government sent in the army later after that, and we decided we all agreed with it. But in the interim, that was the process. And so it's these old ancient principles that really just make much more sense, also much more manageable. Because we're seeing now, I was trying to figure out what exactly was the abuse of power they were alleging. And only by listening to both days did I finally piece together what they were alleging and how vague and nebulous it was. They were really trying to put themselves in a position where they could shift strategies right mid-trial. Say, well, we don't mean this is an abuse of power. We really mean this is. Well, okay, maybe that's not working. We really mean the combination of one and two. Well, if not that, maybe it's this thing over the third. Well, that's why we have due process laws, and that's why we have a prohibition on ex post facto laws and bills of attainder in our Constitution, is so we don't have this moving target style of adjudication. And it's like if this impeachment is greenlit at any level or looked upon favorably at any level, pretty much every president moving forward is going to be impeached. And that makes a joke of it.
No question about that. First of all, I give it her answer. Ethan A. Harrington, yes, I did have a memory block when it came to identifying the Canadian form of government. There's no question. As it is, this is already politicized, the impeachment process, regardless. Because even if one were... I'm a Rhode Islander. Even if one were inclined to believe that the act to qualify for impeachment need not be a crime, it still has to be sufficiently serious. Then the question is even whether or not what is being alleged is sufficiently serious, which I don't think anybody is sufficiently convinced of, except the people who are steadfast on following through with the plan. Here, hold on. Let's say this. We got a super chat here. It says, you guys are focusing on the high crimes, but I feel you're ignoring the misdemeanor part. I think you can imply a minor, but statutory crime. And feel this one, Robert, because I think now I understand the rationale. Like it would have to be a serious misdemeanor, not a small misdemeanor. Thank you very much for the super chat. Hemuro forever.
Exactly, because this was the precise argument made in 1805. And all of Justice Chase's defenders, including Justice Chase, argued that clearly the word high was meant to define both the word crime and the word misdemeanor, and that went to the core of why the impeachment clause existed, to how it interacted with all the other aspects of the Constitution, including the importance of separation of powers. Because if any small crime that did not impact your abuse of office could be impeachable, then basically every judge in the country and every executive official official in the country serves at the pleasure of Congress at the moment of any partisan rage that might storm up at any juncture, any time period. And that was their point, was that clearly can't be what it means. That we didn't, in fact, at the convention, they made clear they did not want to repeat what was happening in the United Kingdom. They didn't like that too many things were being defined as impeachment. And so it's always been important about it. It go to something where you say, can an election fix this? And you have to be able to say, you know what, this conduct is so criminal and so misuses the power of the office that an election can't fix it because of some way in which the office is getting misused, like treason, like bribery, like opening the door to a foreign government coming in and waging war on us, things like that. And back then they were paranoid. That's the reason why there's a special provision against executive officials taking certain emoluments, which has amazingly come back up in the Trump context, which I find insane. But the original, their whole fear was somebody's going to get in power and they're going to decide to anoint themselves king, or they're going to become the president, and they're going to decide that, you know what, I would love to be a duke in France. And I'm just going to sell out the U.S. interest and give the whole U.S. government to France in exchange for being the Duke of Normandy. This is what they are all obsessed with back at the time of the Constitution. And if you understand that context, it informs a lot of how and why they're structuring things the way they are.
It's fascinating, actually. What was I just about to say? Oh, yes, I was about to say that there's 1,078 people watching right now, which is amazing. If Robert has successfully convinced you that a impeachment act to qualify must be a crime, hit the thumbs up button. Actually, I want to see how fast that'll skyrocket. I think you've changed my mind, but I don't want to. The argument that you have presented is extremely persuasive and also responds to exactly the contextualizing of what it was that the founding fathers were trying to avoid. Makes a lot more sense than, in fact, exactly the more sense than the way it's being used today, which is now, hey, if the Democrats or the Republicans held both the House and the Senate, they can get rid of any president duly elected on any spurious basis, which is exactly what the Americans had just freed themselves from and wanted to avoid recreating in the States. It makes sense. I mean, it makes sense. I don't know. There's a lot of thumbs up. No, I don't mean thumbs up in the comment section. Hit the thumbs up on the like button of the video, guys. Come on. There's a lot.
And I'm hoping, if anyone is capable of it, Professor Dershowitz is capable of it. He's one of the lawyers I've read and studied. I've read a lot of his briefs. I've read a lot of his oral arguments, read a lot of his text, watched him extensively. He is one of the smartest lawyers I have ever seen. We disagree on a lot of politics, but we agree about the rule of law, and he's a master persuader. The Democrats would have been well served by trying to find someone like him on their side of the aisle. But I'm hoping he brings that to the Senate. I think the most interesting part of the entire impeachment trial will be Professor Alan Dershowitz's arguments on the floor of the Senate. I think he's going to bring his A game, because I think he feels a lot of pressure from a lot of people, a lot of attacks on what he said and done. And I think he wants to show the world, I'm still one of the brightest, best legal minds in the world. And I'm going to make an argument that's going to last for posterity and history, the way Justice Curtis's argument lasted in 1868, which was so powerful that the Congress refused to impeach any president for more than 100 years after.
No, it's amazing, actually. And I was, from a joking perspective of pride, saying, well, I agreed with Dershowitz 20 years ago, and now he's changed his mind, and CNN and MSM is holding that against him. I got to tell you, your justification for his change of spirit was more eloquent than his justification on CNN, where he got a little defensive, and it wasn't necessarily the best performance live, but the explanation makes a ton of sense. I mean, it just makes a ton of sense. Let me see. We got a super chat. It is Greg Borbanus. The other issue is that Congress, both houses, can define a high crime as anything they want by making it law. So even if that were true, they could make it a law afterwards, but you don't have retroactive criminal law. I presume you couldn't have retroactive impeachment either.
And this was very analogous to the Andrew Johnson impeachment in 1868. So the argument was twofold. One was that it clearly had to be a clearly defined law at the time the conduct was engaged in. And secondly, if it was a sort of an entrapment law, which is what happened, the Republican Congress passed a law that said, oh, Andrew Johnson, if you fire this guy, we're going to call that a crime. And then he did. And so they said, aha, now we're going to impeach you for it. And the problem was the way in which it was passed, how it was passed, the constitutional dubious nature of the law all led to Justice Curtis's argument that this didn't define clear criminal conduct before he became president. And so if it didn't, this is just a way to try to get around the requirement that impeachment be for an indictable offense. And part of it was Justice Curtis, for example, was the justice who famously dissented in the Dred Scott decision. He was actually one of the only Supreme Court justices to ever resign the bench out of principle. The guy was very unique. I mean, he was a little bit cantankerous, like a lot of your idiosyncratic intellectuals are, but he was an extraordinary individual. And that's why when he was on the Senate floor making that argument, and he was naturally eloquent, that it persuaded. I mean, they thought that was a done deal. They had set him up for that purposes of impeaching him. They had an overwhelming, easy 2/3 majority in the Senate, and large numbers of Republicans dissented and said, we're not going to convict. Justice Curtis is right. This is a misuse and abuse of impeachment power. And it was such an effective precedent that, like I said, it wasn't until Nixon that the Senate was even willing to think about using that power again, more than a century plus later. Just like after Justice Chase won his acquittal, they have never indicted a Supreme Court justice or impeached a Supreme Court justice since, because they learned, okay, this is not the right use of impeachment power.
Now, you may or may not know the answer to this question, but when I read through Trump's lawyer's argument brief, they said, obviously, the only presidential impeachment examples you have are Clinton and Johnson before Trump, Nixon to some extent, but not really. In the brief, it said virtually all judicial impeachments were based on crimes. Now, they didn't say all judicial impeachments. Do you know of any example of a judicial impeachment that was not based on an actual crime?
Their main argument is Judge Pickering, which actually happened at the same time of Justice Chase. Very unique case, because what happened was in fact, this was the argument of in Justice Chase's defense, was they said Judge Pickering, what he did was literally a crime. Even if they didn't specifically charge it as a crime, they used different language. They said it really was a crime. And then they pointed out that the defense was unusual, because here's what happened. Pickering was basically a drunk, couldn't handle himself on the bench, which clearly did violate certain criminal laws at the time. So he was impeached. He didn't show up for his impeachment. His son wrote in a letter and said, no, you don't understand. My dad's insane. He's literally insane. So that's why he got impeached. So it was one of those, it was like not the most, that's why they say literally almost all. Now, what's happened since then, in the last 40 years since Nixon, a whole bunch of legal scholars have taken Madison out of context, where Madison was arguing, hey, here's why the Senate makes a good jury. And they take that to mean, oh, Madison's here defining what high crimes and misdemeanors mean. That isn't at all what he was trying to do in the broader context of that. The other is Judge Pickering's impeachment. They say, oh, well, look, he really was just impeached for being a drunk. And so if somebody can be impeached for being a drunk, clearly they can be impeached for being anything. No, he was impeached because he couldn't show up at the bench. He didn't defend himself. And his own son said, and in fact, the Senate didn't like the conviction of the charges. So they never said he's convicted of these charges. They just said he's hereby impeached and removed, because they were trying to dodge the legal precedent that they could be setting. So they were even cognizant at the time, even without Pickering presenting a defense, that in fact, this was a problematic basis of removing him. But it was just, everybody agrees. His own son is saying, hey, my dad's insane. They're like, maybe we shouldn't have him as a judge then. So that was sort of the issue.
I mean, that's very interesting. First of all, Jason San Augustin, thank you very much for the super chat. It makes a lot. Now, so the example that I had two examples in my head where, because some of the scholars were even saying that it could be the exercise of a constitutional power that could nonetheless qualify as an impeachment. And the example they were giving would be, well, the example some gave was selling pardons. That was actually one of the examples that Legal Eagle gave. And my response was, well, no, selling pardons is itself a crime. The question would be, if you just issued egregious pardons, and I don't mean like politically offensive pardons, but like if Charles Manson were still alive and the president pardoned Charles Manson, then I was thinking that I could understand that being an impeachable offense, even though it is within its constitutional powers and not technically a crime. But now I sort of understand the exact flip side argument, which is that can be resolved at the ballot box. If it's the first term, if it's the second term, it will be resolved by the ballot box. Punish them at the ballot box for doing something so disgusting, but that was who the people elected, and it's not a crime that can warrant impeachment and removal from office to usurp the will of the people. The other
exactly. I mean, I think Bill Clinton would not necessarily be a fan of impeachment for selling pardons, given what happened with Mark Richter at the end. But yeah, exactly. Because what they were worried about was behavior. This was my argument back when I was a law student at Wisconsin Law School during the Clinton impeachment era, where people didn't understand because they perceived me as conservative. Why was I arguing for Clinton? And I said, look, this is about universal rules and principles. And what he did might have been a bad act, and maybe they can indict him and toll the indictment pending his release or pending his leaving the presidency. But what he did didn't threaten the republic. It's just not a crime that threatened the republic. And the American public had that instinctual reaction to that. They're like, we don't like what he did, but what he did didn't threaten the republic or undermine why he elected him. That's why the impeachment was always unpopular over time. And I think that the same dynamic is present here. And I think that's the main purpose. It needs to be a crime. And the best, most articulate versions of this were really made in 1805 and 1868 in those trial opening statements by Justice Curtis, ex-Justice Curtis, and by the transcripts of the 1805 Justice Chase impeachment hearings, where they explain it needs to go right to the heart of the republic. Otherwise, we're creating a parliamentary democracy by default.
Amazing. Fantastically interesting. And I think I might have to do a separate video specifically on those opening arguments. I think I may have missed some super chats. The other issues, okay, this one we got. Sorry guys, if I missed the super chat, someone reminded me and I'm going to get down to that. Let me just see. I saw something more we had this one. Did I miss another super chat here? Does Rob think there was a crime committed to impeach over if only Dems charged correctly? Let me just see this here. Does Rob think there was a crime committed to impeach over if only
I think I know what they mean. It was could the Democratic House have charged a crime? I think the reason why they didn't, I would say that Trump has committed no crime. But I think that their logic was, in fact, an old college classmate of mine, Jed Sugarman, who's on the politically opposite side, was arguing that the House should argue bribery, even though he didn't charge bribery because it's referenced in their memo. It's interesting they have not even talked about that at all in these first 2 days so far. And I think the reason is, especially as I saw what they were doing, they don't want to be held to the limits of bribery. They don't want to have to prove the elements of it because that makes their case 100 times harder. So, I mean, and in fact, this whole impeachment was, in my view, reinforcing the reason why those justices were right all the way back in 1805 and arguing on behalf of Justice Chase and the other legal scholars and commentators, same in 1868, because this is what they're trying to do. They're trying to say, we don't like what he did. We think we could make it look bad, but we don't want to be held to a standard of a criminal law that has elements to it, where we have to prove this element, this element, this element, and this element. And I was like, well, that's exactly why we need that. I was honestly shocked that they did not include a crime. It made me frightened about the consequences of this. It's like they're using the controversy surrounding the inherent nature of Trump's tumultuous presidency to try to create dangerous and perilous legal precedents that could restructure our constitutional government on a go-forward basis.
Yeah, or they know it's dead in the water and just try to make it ugly and messy and have a show in front of the Senate.
Yeah, but the thing there is, if even with that objective or a set of objectives, why not allege bribery? Why not allege extortion? People like Harry Litman and others that I've debated on TV, they were happy to make those allegations. Now, I pointed out I didn't think they could get anywhere close to proving the elements of that. And then, in fact, people hearing that might be like, that doesn't quite sound like that. But I thought, why not? If you think you can't win anyway, why not allege the most salacious charge, but also the charge that would conform to the Constitution? Bribery in particular, it's right in there. Treason, bribery. You don't even have to argue whether that's a high crime or misdemeanor. It's indisputable that bribery is an impeachable offense. Now, legally, they couldn't have charged treason. That requires we be at war, so on and so forth. People love to use the word treason and they bounce it around a lot. It has a very limited legal definition. But bribery, they thought, they've said he committed bribery. So I was like, go ahead and go there. And I think at least then it's a constitutionally valid impeachment. We may disagree with whether the facts support it. I don't believe he committed any form of bribery at all. But at least that's, in my view, an honest impeachment, a constitutionally honest impeachment. They chose not to do that. And I'm skeptical of their I think they really do. I think there's people on the Democratic side, even on the Republican side, that want to expand the definition of impeachment and increase congressional power over the executive. And it's natural. If you're in the House or the Senate, why wouldn't you want to increase your own power over the other branches? That's why it's so dangerous and perilous for them to have any vague, put it this way, If abuse of power was a crime, like they've charged it, it would be struck down by the U.S. Supreme Court for void for vagueness. Why? Because it gives too much discretion to individual officers to interpret it and to apply it and to enforce it. And this is this is worse in my view than the Andrew Johnson impeachment, worse than the Samuel Chase impeachment. I think it's the worst impeachment in American electoral political history.
Amazing. Amazing. Okay. Now, Will Carter, I think if I missed your super chat, Will, I'm very sorry. The Cicero quote was, it said, more laws, less freedom. I think we've all.
Yes. I mean, just to follow the Twitter feed of a crime a day. And that's the other thing. Some of my arguments to my liberal friends has been, it's not like they couldn't find a crime. We got like 10,000 of them now. There's got to be something they can say Trump screwed up somewhere. It's terrifying to me when they wouldn't even allege a crime, where today they're saying we don't have to allege any violation of any law. And it's like, what? That's a perilous precedent to set for everybody, independent. In fact, that was the closing statements of both Judge Hopkinson, Justice Chase, Ann Luther Martin, and Robert Harper and Justice Curtis. They all came back to it. In their closing lines, they said, remember, you're unleashing a virus that will come back to plague the inventors of that virus. You will not like this when it comes back the other way. It was my argument to my liberal friends, to my conservative friends in 1998. Was like, you're not going to like this when this liberalization of impeachment comes back against somebody that you're championing. And now we're here. We should put the Pandora back in the box.
Very interesting. No, fascinating. Okay, Michelle M., thank you very much for the super chat. No message, but thank you very much. We got Matthew Maddox, who says, if you could impeach for use of constitutional authority, the veto would be obstruction of Congress. Well, so we're getting ahead of ourselves, but they are, in fact, one of the charges of impeachment is obstruction, which was specifically exercising executive privilege over the congressional subpoenas, unless I've misunderstood.
No, that's exactly right. That's the one that Professor Turley, because he's a different opinion than me. He thinks you can charge abuse of power, but he thinks the obstruction of Congress charge is itself constitutionally offensive, because he says the executive has always got to have the right to go to the judiciary to determine the scope of congressional oversight authority over the executive. And by the way, this is all caused because for whatever reason, Pelosi chose not to authorize the impeachment in advance. It's the only impeachment in history that sort of just came up through the back door. So what happened is, like, the first full congressional vote on impeachment only occurred at the very end of the process. Normally what's supposed to happen is you're supposed to have a bifurcated process where first you authorize the impeachment investigation by a full vote of Congress. It goes to the committee, then comes back. Here, that first part never occurred. And because it never occurred, there's been a long-standing constitutional argument that Congress cannot simply subpoena whom they want unless there's been a full vote of Congress or a specific authorization of delegation of power to that committee for that particular subpoena. The other reason why Pelosi did what she did is she wanted Schiff and the Intelligence Committee to really run impeachment, not Nadler and the Judiciary Committee, which is almost unheard of. It's like, why is the Intelligence Committee, which only oversees the intelligence branches, running impeachment when that has never happened in American history before? It's because Schiff and the parts of the intelligence community were really driving the aspects of this impeachment, and that's why she let him control it in cabinet. Also, as you probably witnessed, Nadler is not the most persuasive guy in front of almost anybody these days. So I think, but because of it, she created an easy White House defense. The White House was like, you haven't fully authorized the subpoenas. We'll go to court and prove it. Okay. And then, so this is the issue, because now this is where politics sort of trumps details, for lack of a better expression. The House never, and I mentioned this in the last video I did, or one of the last videos, that the House never formally voted on the impeachment inquiry to commence the impeachment inquiry. As a result, the subpoenas that they issued were not, what's the word I'm looking for? Were not approved by the committee that was appointed to investigate the impeachments? Or put most simply, they didn't have a congressional authorization sufficient to be able to compel compliance. Okay. So they don't have that authorization to compel compliance. They issue the subpoenas nonetheless. Trump or his executives get these subpoenas and they say, they're invalid subpoenas. We're not showing up. And then let's just say the Democrats, the House Dems say, you're not complying with subpoenas. This is obstruction. Whereas the argument is, what process would have gone into validating the subpoenas had there been a vote
to commence a formal vote to commence the inquiry?
They could have gone through the entire court system and said, even though we didn't do it up front, we believe we still have. Congress is always seeking to expand its subpoena power. It's very hard to contest a congressional subpoena. You generally have to wait for Congress to take contempt action and then defend yourself in court. You're not really given many. Like occasionally, you'll see somebody challenge a congressional subpoena in court successfully, but it's rare. The technical rules are that an individual doesn't have a right. There isn't quote unquote jurisdiction for the courts to contest your individual challenging of a subpoena. Usually you have to let Congress move for contempt. So that would have been the process. And in fact, the Supreme Court is deciding some other subpoenas that they've issued outside of the sort of direct impeachment context currently. They just didn't want to wait for the court system. It's part of what's upsetting members of, like Senator Murkowski, a Republican from Alaska, who's someone who could flip to the Democratic side, has said that she finds their arguments terrible on this issue. She's like, hold on a second. You couldn't wait for the court system. So now you want us to file something that's also going to likely have to wait for the court system. So like, oh, why are we in this? And it's all because the Democrats created sort of an arbitrary timetable. They wanted impeachment decided and determined and adjudicated prior to the Democratic primary starting. And that's why she was obsessed with, hey, we got to get this done by Christmas so that it's over there by February, because we don't want on February 3rd. And we want all the focus to be on the Democratic primary candidates during February, March, and April and May, not distracted by this impeachment trial that might have them off the campaign trail on actual election days. So that's the backstory of what was taking place.
Okay, and we're going to come back to that because it's a fascinating nuance that I suspect a great many people are just not aware of, and people would call it like partisan interpretation. But we'll come back to it in 1 second. Just get rid of go over these super chats. Ken Kier, if good old-fashioned pistol duels were still legal, there'd be less flimsy allegations being thrown around. The current adversarial legal system is broken because there's no honor left in society. Without condoning, agreeing or disagreeing with the comment, thank you very much for the super chat. I want to make sure not to miss any. Scrolling down here because I know I saw a couple. Here we go. Greg Borbonis, the biggest issue with this impeachment is that it's entirely too vague. It's assumptions, implications, some crime somewhere. This would never make it in a court of law for anyone. Too circumstantial. And then the classic argument is, well, this is not a legal process. This is a political process. And therefore, the rules of fundamental justice and due process don't apply, so to speak.
Yeah, and I think those were the arguments that the justices countered in 1805 and 1868, and in an analogous context, the Supreme Court really countered, because when they kicked out Adam Clayton Powell, they argued that that was purely a political power that was delegated to the House by the U.S. Constitution, and the U.S. Supreme Court said, no, your definition of what you can do is subject to constitutional interpretation by the Supreme Court. Your actual exercise of that power is totally within your discretion, but whether or not he did anything that gave you that power in the first place is up to us to decide. That's why I and then later Giuliani were arguing that the courts do have a role here if Trump wanted to ever exercise it, to go to the courts and say, hey, by the way, are these charges impeachable in the first place? Or is this an abuse of impeachment power? Because I think the Supreme Court would have the right to determine whether or not what the definition of high crimes and misdemeanors is. I don't think that's subject to the caprice of Congress.
No, and if the Supreme Court determines that it was abuse of the impeachment process, do all the House Democrats become impeachable for abuse of the process?
Correct, exactly.
Let me pull this one up here. We got another super chat. Thank you for standing up for what is right in the USA and Canada. I'm an American and I have 4 generations of Canadian family members. I take both USA and Canada politics seriously. Thank you very much. Candy de Leon, thank you very much for the super chat. Thank you for the comment. This has been fascinating for me because I've learned stuff that I've never known and that I never thought I would ever have an interest in learning. Thank you very much for the super chat. Now, I think I missed 2 more. 1, 2, maybe I missed 3 more. I want to get back to those subpoenas, so don't let me forget about the subpoena issue, because that I suspect people are going to write it off as a talking point. Chris Ames, are there any consequences for the way the House railroaded impeachment through, i.e. denying minority hearing, constant breaking of House rules? Okay, we're going to get to this because the minority day hearing was the first point I texted you, Robert. I said I want to talk about. Give us 5 minutes, Chris, to get to that. And thank you very much for the super chat. Let's do one more down here. I saw one more here. Jeff Holland, all future presidents will be paranoid about anything they say on phone calls with world leaders in case a spy from the opposing party are listening. Yeah, well, You know what? When you have the media on your side, it becomes much easier to be less paranoid. My 2 cents and my observation from Canada. Robert, what do you think?
Well, I just always have loved Earl Long's advice to people, which is never in writing and always in cash. So there's some utility to that. Trump's clearly not used to these transcripts of phone calls. He's used to being able to say whatever he wants on a phone call. So I have no doubt he hates this limitation on his ability to just do foreign policy his way. I think you will see in a second term Trump desperately avoid phone interactions, avoid any form of documented interaction, because he hates this constraint on his ability to operate and negotiate. He thinks that he needs a certain liberality of action, and you could agree or disagree with that style or template or his substantive policies. But I think from a executive standpoint, I think every president would probably think the same.
Well, I mean, the funny thing is, I think that the transcript is as much as he might hate having had it, is probably going to help him more, because at least in the presence of the transcript, the hearsay testimony or the other testimony can only deviate so far from the transcript in its interpretation of what went on. But yeah, there's no question he's definitely not used to it. But I think, in as much as this impeachment process might set the new norm for the impeachment standards going forward, Trump, I think, for good or for bad, has set the new norm for presidential conduct, or at least social media presidential conduct on a going forward basis, where we are, it is a different world in terms of what is going to be acceptable as the new standard going forward, whether or not people like it. Jason L., can you talk about Trump's legal team argument that the Senate can't even vote on the articles because they didn't break individual charges, but instead squashed multiple charges into one charge? That was in the argument brief. We'll get to that in a bit. Jason L., thank you very much for the super chat. There were 2 more. Then the subpoenas. Then we do the minority day hearing. Superman, thank you very much. Andrew Starr, what do you think of them questioning future elections before they have taken place? Hey, I remember this from Canada. No, Trump, the elections are not rigged, and now not only are they rigged, but they're rigged in advance before they even start. Robert, what do you think?
Yeah, I thought it was a big mistake of Schiff to go there, because that's going to be used against him and the Democrats for a long time going forward. It's already one of the most memorable and memeable moments of the entire impeachment process. It's, hey, look, they're trying to do a coup. They're trying to prevent us, the voters, from having the control over the future of the presidency. And he said it explicitly. And I get what he was trying to argue. He was trying to say, hey, he's contaminated the branches of government so badly that we'll never have an honest election moving forward. Aside from the persuasion component of that, it was just bad politics, bad optics for him. He should have stayed away from that issue. He should have just made it a clean street, straight, neat, narrow. Hey, look, this is someone abusing the presidential power. We think the only remedy is impeachment. Here's the evidence for it, and come across that way, and not use lots of adjectives. There's like 1,000 adjectives to 2 nouns. It's just it's not good legal argument at all, in my view. I think the people who don't like Trump are going to think the argument's fantastic just because they like hearing any argument that reflects their own opinions. But I think a lot of objective observers who have watched this have thought this is not good argument substantively or stylistically. People like Scott Adams are like, this is just like every bad form of persuasion that exists.
Well, and it's not just that, but it also it casts doubt on the motivations, because this should all be retrospective and not prospective. It's not because he might win in 2020 that you're impeaching for what he allegedly did in 2019. Exactly. It does feed the narrative that this is about preventing the re-election and not about punishing an actual not indictable but impeachable offense. Thank you very much for the super chat, Andrew. Jacob Gestetner. My question is, if this opens the door that every president would be now impeachable for doing his job. I think for doing his job, if people don't like what he does, it certainly now is allowing anyone to interpret anything in a negative light and then argue that it can be impeachable.
Exactly. And the other problem is each party's base is now going to demand this as a remedy whenever the opposing party's in the White House. That's where, unless this is shot down in such an assertive way that people second guess ever doing it again, That's where I'm hoping for an Andrew Johnson, Samuel Chase type ending to this. I don't think we'll necessarily get it, but I think we need it. Otherwise, like let's say Biden wins in 2020, I guarantee you he'll be, as soon as the Republicans have the House, which will probably be in 2022, he'll be impeached within like months of them getting in there. So it's like, why do we want to keep going through this over and over again? Let's trust voters to make decisions. And unless the president is so dangerous to not being able to trust voters to get there, because voters somehow have been stripped of their power by something he's done illicitly, like treason, like bribery, unless it's something like that, like some of what Nixon was doing. Unless it reaches that level, we should be afraid to touch the power of impeachment, not eager to touch it.
And mandatory carry. Thank you very much. I hate Donnie as a man, but he didn't commit a crime. Hashtag if it's not impeachable, if it's not indictable, it's not impeachable. Thank you for the super chat. Okay, now this is the question. Sorry. Some people are going to say that the argument about the subpoenas is a legal technicality, right? Like if I get a subpoena to show up as a witness, but they leave it under my door and they didn't serve it on me in person, and I say, well, I'm not coming. And they say, well, you have the subpoena, you know that the court date's here. And I say, too bad, serve me properly. Some people would say that that's playing a legal game. And then lawyers might say, well, okay, serve it properly if you want it to be enforceable. You're going to have people saying that that Trump exercising executive privilege or arguing that the subpoenas were invalidly served or unenforceable is just playing the technicalities, just abide by them, and your failure to do so is obstruction. What's going to be the response? I mean, what's the response to that above and beyond the law is the law and abide by it?
I think it's more of the universalist approach that every day ordinary Americans defend themselves against powerful institutions, including governments and corporations, by relying upon their ability to assert their rights to defend against things like subpoenas for depositions, testimony, or documents or information. And that it's scary for someone to start calling that obstruction. To start calling that quasi-criminal, to start calling that something that they can punish you for, which is what impeachment is. It still is punishment, even if it's not criminal punishment. And so I think that's the thing that I think is their most resonant political argument, rhetorical argument, policy argument, is that every day ordinary Americans rely upon something like this to be able to defend themselves in court and compel going through the proper process so that they can protect their individual rights and liberties, because usually that process is there to protect rights and liberties in the first place. In other words, you make it that I've always argued there's no such thing as technicalities. There are rules that are designed to defend people's individual rights and remedies, and they've been reduced to a formalistic technicality because that's the best mechanism that we have available to make sure rights and remedies are protected. And that would be my general view. They also have the argument of it would have been easy for them to just take it through the courts. If their position was wrong, if the House was right, that they were entitled to this information, that they could simply go to the courts and get it. And the courts had been eager to usually be on the Democrat side over the past several years. So their unwillingness to go to the courts, like in the case of John Bolton, said he might comply with a subpoena. They decided to never subpoena him. There are other people they decided to subpoena, and they said, I'm going to object. They could have easily gone right down to the courts, and they have in a wide range of other cases and contexts. They chose not to hear, which suggested that they were worried they were going too far afield, that even the Democratic-oriented courts, and they still are oriented that direction, particularly in the D.C. Circuit and the D.C. District Court, which would have decided these cases, that they were afraid they were going to lose. So I think that, but as a whole, it's just that all of us as lawyers advise people to rely upon often what are looked at as technical defenses, to all of a sudden say, hey, we lawyers are now engaged in obstruction because of it. It's something that always bothers me. Because I find that a frightening precedent, because it basically discourages and deters lawyers from challenging institutional power when they have a legal reason to do so.
Now, it's fascinating, and I hope people can really appreciate that, because setting aside the politics and all of this, we're both lawyers, and I always got frustrated in the practice at the technicalities, and I served it, you have it, but it wasn't served on you personally. And but we're not friends. It's an adversarial process. There are not technicalities, but rules of governance, so that you don't get to a situation where someone was slipped under the door with an envelope. They now have it, but they didn't show up, and now you go after them for contempt or for whatever. And so they're not technicalities; they're rules. And once you start not applying the rules, it's not a slippery slope. It's just the throw out the book, throw out the procedure, and just have willy-nilly whatever you want. And it's not how it works. So just abide by the rules and you won't have a problem. Or if you didn't do it, just, okay, suck it up and do it next time.
I always analogize them to safety rules, like in the negligence context, that you might be at work and think this rule really doesn't seem to make that much sense or is that important. But often that rule is there to make sure some bad thing doesn't happen to somebody. And that's what the legal rules are too. They may look technicalistic, they may look formulaic, but in fact, they're there 90% of the time. There's sometimes where they're bogus rules for bad reasons, for old historical, inapplicable policies. But a lot of these rules, particularly this rule, is just designed to force Congress to decide whether or not they want to go forward with an impeachment investigation before they start invading other people's privacy and privilege about a subject matter they haven't chosen to vote on. I mean, this wasn't that radical a step to take. They've taken it hundreds of times in prior impeachment investigations over 200 plus years. They chose for some reason not to do so here. They should have to face the consequence of that choice.
Fascinating. Okay, let's see what we got here. We got Ross Lloyd, currently active duty military, getting out in a couple of years and using my GI Bill for law school. You are both an inspiration. Thank you for this. Thank you very much. I don't want to deter you from the practice of litigation. Robert loves it. Anyhow, I have my thoughts on it. But thank you very much, and good for you. Enjoy it. It's a fun ride. Let's see what we got here. I want one question about John Bolton before I forget it, and I think I just missed. Did I skip? Oh my goodness, I skipped a few here, didn't I? Okay. We've got Andrew Starr. What do you think about Judge Napolitano's arguments? Do you know which ones he's talking about?
Yes. Ever since Trump denied him, apparently not, he convinced himself he was going to become the next Supreme Court nominee. I don't know how Fox News appearances inspired him for that. He's never been confused with a scholastic scholar. I will say in his defense that he has praised a lot of legal cases that I've done before, so I can't be too harsh on the guy. But I haven't found his arguments very persuasive. I've been disappointed, honestly, in the legal academy on the left. Now, there's a Harvard law professor, his name is blanking me now, but he wrote a response to Tribe on impeachment, but he has a much more nuanced position, and he clearly hates Trump. Some of those people, I think, are trying to be consistent. Professor Turley has a very different opinion than I do and Professor Dershowitz does on the issue of the indictable, impeachable connection. But I have no doubt that he's trying to sincerely follow the rule of law in his analysis. But no, I don't. Napolitano has just been anti-Trump now for a year and a half. So I just don't take a lot of his arguments all that seriously. I mean, it's not just his motivation. It's just when I listen to him, I'm like, well, that's not really a legal argument. You're not giving me precedent. You're not citing some historical analogous context. You're not giving me the policy reasons and rationale for the rule. You're not rebutting the arguments I've seen and read that seem persuasive to me. So they don't have the methods of good argument aside from my disagreement with its substantive content.
Okay, very interesting. Thank you very much, Andrew, for the super chat. Draken, love watching your videos. Thanks for taking the time. Always look forward to them. Thank you very much, Draken. There was one more before we get to the Minority Day hearing, which we can't forget about. Okay, Gus Johnson, who breaks the tie, Robert or Roberts or Pence? Dang, you guys are smart. Wish I knew half as much as either of you. Thanks for the education. Gus, thank you for the super chat. Thank you for the question. There is no tie. It's a not super majority, but it's in 2/3 majority.
What it is he's probably thinking about the procedural votes prior to the acquittal vote. Okay. So all of the votes on witnesses, subpoenas, documents, those will be by majority. There has been a lot of confusion because of the language of Justice Roberts presiding over an impeachment trial. He doesn't have any voting power whatsoever. He can't order an acquittal. He's not like a judge in any regular case. He's there simply to sort of procedurally regulate the proceedings, but doesn't have any voting power of any kind. And that's why you haven't seen him say much. His role is exactly what Senator Collins had him do. Senator Collins was the one who sent him the note that said, could you please remind everybody to quit being so mean to each other and quit meaning, and the rest. And that's why he said what he said. I think he probably felt that himself, but he wasn't going to even say anything until a senator asked him to. What the anomalies, like the proper phraseology for the Senate during this time period, going back to 1805, is the High Court of Impeachment. They are both the judges and the jurors, though they act only as a collective unit. Now, their collective unit only matters to the degree it's a majority on a procedural vote or 2/3 on an acquittal vote. Of my understanding, though this is not clear to me actually, as to who splits the 50-50. So this is a good question. I was trying to figure this. Roberts, I know, doesn't have a vote. So, but I'm not sure if, I guess Pence would. He's normally the president of the Senate. It's the weird, what it is the language is the Chief Justice presides over the impeachment trial. To my knowledge, but he doesn't have any voting power. So it's a good question that I don't know the easy resolution to. It's usually up to the Senate's own internal rules. The Constitution doesn't require one thing or the other.
Does Roberts have, first of all, Gus Jackson, thank you very much for the super chat. The question, does Justice Roberts have any sanction power?
Not really. And so he can do things like, hey, be nice to each other, that kind of thing.
He can't expel people from the room, hold people in contempt.
Nope. None of that.
Locate.
That's where really the Senate, he's like a mediator.
Okay.
Is really what he is.
Okay, we're just going to burn through some of these very quickly. Mark Farrell, how can Senate rebuke this impeachment precedent? How can they
by voting no witnesses, nothing. Next time, charge actual crimes, dismiss as a matter of law, acquit as a matter of law. That's my recommended remedy. Send a loud, clear message that the House hears that, okay, we better not try that dumb thing again. That would be my recommended remedy.
And when you say dismiss with no witnesses, we're going to get to that because that's one of the questions that I want to make sure we're all clear on. Jason San Augustin, please make a prediction on what happens to Trump. I'm predicting an acquittal. That's no dog in the race. Acquittal is just going to be on what terms, or with what level or degree of admonishment. Now that word's in my head.
Yeah, I think there's two different things because they could always vote to rebuke, but I don't think that would happen. That was in I think maybe they actually did do it in Clinton's case. I never remember. I know they were contemplating it. I think they censored him. I don't see anything like that happening. So I think the big issue, the real lingering issue is, are they going to allow this to get dragged out? Are they going to have actual witnesses in the Senate? That did happen in the old school impeachments, but in Clinton's impeachment, that was all done quietly. Also, the internal rules that they passed for this impeachment require that they depose anybody before they allow them to testify. So if the Senate approves witnesses, it's almost a guarantee of an extensive delay in the impeachment trial. Because there also could be people may object to appearing. They may have court hearings. They may have to go through all the way up to the Supreme Court. So you're talking about this could drag out throughout the whole rest of the year if they actually allow witnesses to appear. And on the flip side, you're going to have Trump people demanding that their witnesses appear. They're going to say, hey, if you want your witnesses, well, we want Hunter Biden on the Senate floor. We want Joe Biden on the Senate floor. We want people like that on the Senate floor. Hey, I personally, that would be great drama. Could be fun. Though in watching all of these congressmen do cross-examination, I'm not looking forward to that part of it. These people just do not know how to ask a simple cross-examination question. It's usually like a 5-minute lecture, then a confusing 6 sub-part question.
I've done a bunch of videos on that where there's grandstanding, but then you can still get to some good questioning afterwards. There are some who do it much better than others, or who did it better than others in the House.
Yes.
But that's sort of my judgmental observation as well. Okay, we're going to come back to that in 1 second. Just I know that you're going to have an answer for this question. Doug Confer, how does Obama invoking executive privilege during Fast and Furious is different from Trump's invocation? If it applies in one case, why not the other?
Yeah, not only that, I mean, there was some talk today from Nadler about how no one has ever objected or obstructed Congress like this before. And I was like, well, I thought just 4 years ago, the Attorney General of the United States for President Obama was held in contempt of Congress because he refused to comply. The IRS commissioner was held in multiple counts of contempt. It took the Fifth Amendment before Congress, the actual IRS living commissioner, on a case that I was tangentially connected to. So in my view, it's all the same. Executive privilege is executive privilege. I don't actually agree with the scope and scale of what the presidents, including Trump, have argued is executive privilege. I believe in a democratic process, little d democratic process, more transparency, the better, more openness, the better. But it's definitely the case that the Department of Justice universally takes the executive privilege position whenever and wherever and however they can. And so arguing that this somehow is new and novel and unheard of is not one of their better arguments. I mean, frankly, they should have dropped the obstruction claim altogether. They should have taken, usually the impeachments have multiple counts. What they should have done is abuse of power and each crime that they think attaches, because they implicitly are arguing, or at least some Democrats are arguing bribery. Some are arguing, so the count one should have been bribery. Count two should have been abuse of power, a specific violation of a specific crime, whether it's the Impoundment Control Act or the federal election laws about soliciting foreign donations or whatever they thought legally really fit the circumstance.
Don't give them any ideas, Robert. they might go and amend their impeachment articles, but I'm joking.
Well, there's people already talking about what they're going to impeach on next. Pelosi's already made it clear that she thinks this is just one round, that they're not limited. Now, I don't think they're going to be dumb enough politically to keep impeaching him, but you never know. I mean, the Trump era has revealed some crazy tendencies within the legal and political institutional processes in their response to an unusual president.
Okay, two more questions that we're going to get to this. Shubzilla says, what if the GOP drags this out until the Dem candidates demand to be shut down so they can campaign? So I'm shaking my computer. My understanding, they can't, and if they can't campaign because they're sitting in the Senate trial, tough noogies for them?
I mean, yeah, there's, if in fact, as long as the Senate trial lasts, there's nothing they can really do. They're sort of effectively sort of locked into the Senate chamber. Now, they've been loosening, they're not enforcing those rules. So like today, about 25 senators from both sides frequently left the hall, and that's going to continue to happen. And that would even accelerate over time. But there's no question. I mean, what I would recommend if I was strategically recommending, advising the Trump team, is if any authorization for witnesses or documents goes forward on the Democratic side of the aisle, then there has to be votes on bringing in Hunter Biden, Joe Biden, subpoenaing a bunch of records related to Burisma and both. That will drag it out for several months. It will also, no doubt, embarrass Joe Biden's campaign. Joe Biden he has more to risk than Trump does with this thing getting dragged out, in my view. There's a reason why his son is dodging subpoenas for his speaking of subpoenas and dodging them. He's been dodging them, and he has a contempt hearing coming up in Arkansas because he has not wanted to disclose any of his financial information in a child support case, likely afraid that it will leak. And that there's something in there that will look bad for his father during the campaign or during the impeachment proceedings.
Yeah.
So I think that's just one sign of the risk that's out there. Also, the fact that Democrats were afraid to allow Republicans to call pretty much anybody in the House, going back to that earlier super chat question, that was reflective of there being evidence out there that looks bad for the Democratic side of the aisle. So every lawyer would love to just present our own witnesses and not allow the other guy to present his witnesses. That's the nature of the animal. But that's usually because the other guy's got some arguments and got some evidence and got some witnesses that aren't going to make our side look so good. I'm sure that exists. And that's something that Trump and Republicans have not had at all yet to date. So that's where I think Democrats may be. Here's what the Democrats want. They want there to actually be no approval of any witnesses. But they want to be able to go out later and say it was a sham trial. They didn't call any witnesses. They don't want to actually go down the path of actual witnesses, I don't think. I think that's why they handled it the way they did. They want the political argument with, I mean, I've done this at times. So like I'll put forward a settlement proposal that I hope the other side doesn't really take, just so I can use it later in leverage. And so this is not an uncommon political or legal tactic.
And actually, that's a question I'm going to ask you in 2 seconds. Thank you very much for the super chat. Mark Mace, no comment, but thank you very much for the super chat. There was one more here. Oh, Mark Mace, okay. I've noticed the pundits have shifted focus from Giuliani to Bolton in recent weeks. I don't believe Bolton has anything to offer beyond what Fiona Hill offered at the House hearings. Any thoughts? First question first, why didn't they subpoena Bolton? In your humble opinion?
Because they're scared that he might say stuff that undermines their case. Okay. So he's one of those, the classic don't ask a witness something you don't know what the answer is going to be, which I have a contrarian take on that. I think sometimes that's the only way you can get to a case. I mean, sometimes it's a gamble is how I always put it. It's not a locked in rule for me. I've found wonderful answers at times when that happens. It's a gamble. You recognize it's a gamble, but that's what it is. Bolton fits into that category. They're afraid he's going to get up there and he might totally undermine them and say, oh, I didn't think there was anything illicit about this at all. And the reference I had to drug deal was a sarcastic joke and comment. I didn't think anything of this was problematic from the president's perspective. And I know the president was trying to do something legitimate and all these other people were undermining him. And that's why I said, go to the lawyers to protect the president. They're afraid he might say that. They're hopeful he would get up there, and the Republicans and Trump are nervous that Bolton would get up there and say, oh, it was all, I knew it was illegal, and I told the president it was illegal, and the president still did it anyway. But but nobody knows what he's actually going to say. And so he's a big gamble for both sides. And for that reason, I don't think he'll ever get up there. I do not think Bolton is willing to burn his whole career to take after Trump. It's one thing to be antagonistic to Trump. It's another thing. And what Trump has shown is if you're on the Republican side of the aisle and you try to burn up Trump, it's you who's going to end up burned up. So politically speaking. So I think anybody talking to him would be saying, maybe don't commit political suicide just yet.
Okay. Fascinating. Mark Mace, thank you very much for the super chat. There's more. Okay. Before we get to that, one question here. Okay. When the Democrats are complaining that they're not able to call witnesses or that there's an issue about calling witnesses before the Senate trial and they're using the word cover up. Okay. Is that my understanding is that what's going on is they're saying you're not calling any new witnesses now that have not already testified before the House. We're going to rely on the House evidence, the House testimony. If it was good enough to approve articles of impeachment for the House, it should be good enough for the trial before the Senate. And so when they're saying no witnesses, they're actually saying no new witnesses that have not already testified. And in that sense, that's how they mean it. Is that an accurate understanding?
Absolutely, because they've been presenting witnesses, presenting the video transcripts of those witnesses, the verbal transcripts of those witnesses, documents. That's why I've been telling people that what they're doing is actually closing arguments, disguised as opening statements, but the Senate rules called them opening arguments. So they're really like what you might see in a TV show where somebody does an opening statement that's really a closing argument, because 95% of what they've done in opening statements, you could not do at an actual trial. You couldn't, have the accusatory tone or adjectives throughout. So in fact, the way you could think of it is all of the evidence that they submitted, that they gathered in the House, has already been really introduced into evidence in the Senate, because that's how they're able to cite it, play quotes. Now, they got away with stuff they would not get away with at trial. One of my favorite rules of evidence in the federal rules here in the United States, Federal Rule 106, is called the rule of completeness. I use it all the time in my cases. Used it famously in the Snipes case to introduce my entire pack of evidence through the government's first witness. And the goal is what is it? It says you can't take a certain person's statement and not put into context all of the other statements they made pertinent to that if it contextualizes it. They've been abusing the heck out of that throughout the Democratic presentation. It's one part where what I've been telling people is I know the rules of evidence don't apply in the Senate trial. They've chosen to not apply them. That's their privilege, and I understand why. And there's a certain informality that justifies it. But there are some rules that we have designed because they are critical to avoiding untrustworthy, unreliable information from being presented to the decision maker. And the rule of completeness is one of those rules. Hearsay is one of those rules. Lay opinion is one of those rules. Those rules, I think, are fundamental and essential. They're not formulaic. They're not about how you stamp an exhibit. They're about, or the timing of presentation. They're about making sure you're getting competent evidence presented in a correct manner. And so I think the Senate should have added a few of the rules of evidence to this, and not only would have streamlined it, it would have made it much more fair, much more truthful in its seeking. And I think people would even perceive the Democrats' presentation better because they would say, okay, that's the whole statement. Instead of people being like, hold on a second, they just cut out 1/3 of the statement from the top to the bottom, and everybody's had that happen to them in their lives. That immediately discredits everything the Democrats are doing. They're not persuading anybody but the choir.
And that's interesting. So that would be the equivalent of saying when you file a transcript of a deposition, if you file page 107, but you need to file page 106 and 108 to understand 107, you don't just get to file page 107 on its own. And if you do, the other party gets to say, whoa, we need the page before and the page after to properly understand it. That would be the literal that's the analogy of what you're describing now.
Exactly. It's like you write a letter, or let's say you're writing a letter in response to somebody else's letter, and you can't really understand your letter unless you see the letter that you're responding to. That's what the rule of completeness is all about avoiding. Don't take a statement out of context that misconstrues it without knowing the context.
Okay, because I was hearing, because I do watch all the news, and I was hearing one side saying it's the cover up. They're not letting any witnesses. They're not letting any evidence. And it's like, well, wait a minute. I thought all of the evidence that was adduced before the House to approve the articles of impeachment, sufficient to approve the articles of impeachment, is going to be before the Senate, and that's the case. And so the flip side argument that I have is, I said, if they're not allowed to adduce evidence now, it's going to be a cover up, and that means that the evidence on which they approved the articles of impeachment was insufficient or would qualify as a cover-up, then what did they approve the articles of impeachment on if there wasn't, adequate evidence? And so that is to say then that Turley said this in a number of his papers. You want to adduce evidence now, you should have just done it before the House investigation or the House inquiry. Complete your file there, and then you bring your file for the trial, and not try to complete what is the word I'm looking for? Inadequacies before the Senate trial.
Or what they're really doing, because I heard, it's always shocking the bad legal advice you get during these kind of proceedings from people who haven't practiced law or are so political they're just bending the law. Because people are like, oh, it's totally normal to be able to call any witness you want at a trial. And I'm like, well, what trial have these people been to? I don't get to go to trial and say, you know what, that person I didn't depose and didn't tell you about, here they are, and they're key, and they're going to totally change my story. Every judge would say, no, that witness is excluded. So you can't do trial by ambush. That's the popular phraseology, at least in American courts. And that's what they're really doing. And what's amazing is Turley warned them to not do this back during the House proceedings before they had voted on impeachment. He said, hey, take your time and develop your case. Let's see if your case is good. But hey, let them have their side. You put in a bunch of evidence. You go through the whole subpoena process with the courts. Let's get to the whole bottom line and see a whole record. Don't rush the case for political purposes. But they ignored him because elections are coming.
Yeah, no, it's amazing. And I remember him saying that. He said, this is not how you do it. Build your file. Your file's incomplete. And they listened to Feldman and pushed through. Yes. Alexander Victor, any foreseeable precedents that comes out of this?
There's no doubt about it. I think it will be substantial. So how this gets voted on, how this proceeds, and how this is perceived, both in the legal academy and in other settings over time, will have great impact on the future use of impeachment. So if a vote comes back that says this should never have happened, this impeachment was wrong in the way it was processed, wrong in the way it was charged, politicized in the entire process. This is the only presidential impeachment where the bipartisan vote was against impeachment, where you did not have at least somebody from both parties voting for impeachment, and where you did have people from both parties voting against impeachment. I would love it if they shut this down. I think it's a dangerous tool that allows politicians in the moment of political rage to take action that's against the democratic will of the people. Take your argument right to the people, persuade them why this guy is wrong.
But now the question is this, and I was thinking of this, what sort of precedent, what sort of sanction can come? The vote is yay or nay, right? So it's not like there's a written judgment that says there was gross abuse of process by the House. It is just going to be a yay or nay. There's no written judgment to sanction anybody.
No, what they could do though, if they denied witnesses and said a motion to dismiss was filed on the grounds that it was that this does not constitute a constitutionally cognizable impeachment, because if it's not indictable, it's not impeachable. If they granted that motion to dismiss, that would be the first time they have done something like that in the history of impeachment proceedings. So great. That could set a precedent. Okay. I don't think it will happen, but that would be my wish.
All right. We got Benton Thrasher says, from both of you, is there any road at all to this that leads to an actual conviction here, even if it requires some GOP voting against the line? Robert, you're better. You have been better at political predictions, or you've been very good at them. I won't make one. What do you think? Thank you.
I would say the odds of that are about 20-1 against that occurring, but there is a risk because there's a large number of senators who dislike Trump. And the reason why Schiff's team keeps referring to the Ukrainian policy as one of their primary themes throughout their presentation is because a lot of senators on the Republican side support that hawkish policy in Ukraine. You're seeing a lot of people on the anti-war left who didn't like Russiagate also not like this impeachment because they don't like it for the same political reasons. People like Aaron Mate over at The Nation, Michael Tracy, who's been at a wide range of publications, Glenn Greenwald at The Intercept, other places like that. They don't like this impeachment because they understand its underlying foreign policy nature. They don't like hearing rhetoric like we're at war with Russia. But there are a bunch of senators who do on the Republican side. So that's Trump's risk. There's a lot of the senators who've never liked Trump would have liked him not to be there. I would say this. I think what they fear is it would be the end of their political careers if they voted to remove Trump. and they have no idea what they would be unleashing nationwide. There's already a large number of people in this country that have given up on our political institutions. We're lucky if we get half the country to the polls on a presidential election day. What happens if the president who says the deep state was out for him gets removed? Their interpretation is going to be that this is no longer a little d democratic country, that the institutional politicians and institutions in general have more power than their vote, than their franchise. I think that would be a very dangerous thing for the country going forward.
That's very interesting. And Benton, thank you very much for the super chat. Also, I would only think rationally is that anybody who decides to vote for an impeachment on this basis themselves will become subject or the object of a potential impeachment for a similar purpose. So like everyone's just gonna the revolution ultimately eats itself. So even if they think they're doing it now just against Trump, they will be on the cutting board, so to speak, down the line themselves. Okay, there was I saw one more. I'm a little bit lower here on the super chat. I think I missed one super chat, and I'm sorry if I did. Was it this one? Here we go. Andrew Smith. Robert is on fire. Thanks, both of you. The inquiry was so unfair that it's hard to take this trial seriously. This is exactly where I was going, just as a pure matter of Andrew, thank you very much for the super chat. Thank you for the question. Minority Day hearing. I pointed it out in one of the videos when Nadler banged his gavel, said it's not a cognizable point of order right now. And Collins said, this is non-discretionary. Give us our Minority Day hearing. And it never occurred. Look, okay, to dumb it down, my understanding, Minority Day hearing was where the Republicans called their witnesses in the context of the impeachment inquiry. How did it not happen? And how is that not something that fundamentally taints or invalidates the process?
No doubt. I mean, because during the Clinton impeachment, the Republicans gave that Minority Day hearing to the Democrats, allowed them to gather all of their evidence, allowed them to have witnesses testify. They actually went about it the procedurally correct way. It was the beginning of a transition where in the mid-90s, a lot of your Republican types became rule of law folks, which it hadn't always been that way. And Democrats increasingly sort of had a Michel Foucault approach to the law, which is that law is just a tool of power. And it's whatever we want it to be is what it's going to be. And increasingly did not believe in the rule of law as a principle. Dershowitz is a throwback. The old left still believes in the rule of law, but the young left does not. And so, and I think that's what it reflects. Schiff is a power guy. So Schiff was like, nah, I can do whatever I want to do. We got the majority, and we're going to show you how you should exercise power as a majority. You silence the minority. Now, the problem with that is it looked bad. So it's like, aside from the fact he could get away with it, and then it could serve his case in the sense of certain evidence not developed or exposed, in my view, is long-term politically and from a historical perspective, damaged his presentation. Because people are like, I've always been like, I'm all like, during depositions and the rest, I don't object much at all, because my view is I'm not scared of the truth. During trial, I almost never object, in part because jurors hate it, but also because I think it mostly intrudes and interferes with the presentation and is perceived as obstructing truth more than it is getting at something. So it has to be something really fundamental for me to object, not some technical formulaic, well, you asked this question this way and it should have been that way. So if it's a fundamental issue, if it's calling for speculation or absurd lay opinion, like what we've seen in these proceedings, I would have probably objected every 5 seconds during this impeachment trial, but in any other context would not normally. And it's, I think it was unfortunate that they did that, because now they've created a situation. They've also complicated their situation now in the Senate, because their argument for witnesses would be much more persuasive if the House had the Republicans and Trump had their chance in the House, and it would not be as risky, because now if they get witnesses, you can almost guarantee people like Graham, who don't want to call Hunter Biden, who's friends with Joe Biden going back a long time. It's a key hidden factor here. Joe Biden was a longtime United States senator. 2/3 of the people in that room, including Republicans, are personal, close friends with him. They are not going to want to embarrass him whatsoever. But they're going to be on the political hot seat if witnesses get called, when Republicans didn't even get their day in the House and Trump didn't even get his day in the House. So not doing it, I think, set them back tremendously in terms of getting any outcome out of this other than a short-term political hey, look, we impeached Trump, send me money this week routine.
So, I mean, that's the funny thing, because like I see for whatever it's going to set them back or set a bad precedent on a going forward basis, it's certainly got no contemporaneous coverage, because in the original video that I made, and people are like, hey, whatever happened with that Minority Day hearing? And then impeachment comes and goes. Like, yeah, I had to look up as to whether or not they ever got the hearing, and they didn't. So, I mean, and that's the interesting thing also is now you have them saying the only people, it seems to me, that could legitimately argue that they need witnesses before the Senate would be the Republicans who were denied having any witness testimony to counter the evidence before the House.
And there is, by the way, a constitutional argument dating back to 1805 that this is a criminal proceeding, or what they would call a quasi-criminal proceeding under the Constitution. And that would mean due process rights attached, but not only that, right to counsel, right to confront, and most importantly, the right to confrontation is the right to subpoena witnesses. So the only person who would have a right to do it is the president. Because this is now a trial and this is now a quasi-criminal proceeding. And that aspect of it could probably be reviewable by a higher court. The court has said how you do a trial doesn't necessarily matter. But the issue of, well, what if you denied a witness, the person being impeached, the ability to call witnesses he claims are necessary to his defense? That has never been yet adjudicated by the Supreme Court. And many of the great legal scholars dating back to 1805 argue that would be necessary because this is constitutionally a quasi-criminal proceeding.
It's fascinating. I mean, that was raised in the argument brief. There was a whole big section on violation of due process. It'd be interesting to see if it gets to the Supreme Court on that basis alone. So we got a question. Noreen Moss says, doesn't the Democrats' case infer the Clintons and Bidens are guilty? I mean, I can sort of hypothesize, even if it does, it doesn't matter because they're not the ones on trial right now. But Robert, what do you think?
I think it's something that they pointed out is because people have been asking, okay, how exactly did asking for an investigation into Biden constitute impermissible interference in the U.S. election? And so one of the contentions is this one here that says it seems to be that the only way it could actually constitute interference is if the investigation would reveal Biden is guilty, because if an investigation occurred and it cleared Biden, that wouldn't hurt Biden at all. It would actually help him. So their point was, why does the mere existence of an investigation constitute illicit interference to undermine your opponent? The argument the Democrats make is simply the announcement of it would have been harmful, which is an interesting position because they didn't seem to have any problem, the Obama administration, leaking that Trump was under investigation during the 2016 election. So my own view is I don't understand how it and I think it's why they didn't charge bribery or violation of the foreign donation laws. To me, it's not clear at all how this constitutes illicit interference. Like, one of the things that people don't fully understand is that foreign interference is actually not illegal. What's illegal is soliciting cash for your campaign or something that's equivalent to cash. And the reason for that is First Amendment limitations. I also tell my Democratic friends, think real long and hard about saying any involvement by a foreign citizen in the United States is criminal, because that's pretty much every dreamer in the country. That's pretty much every illegal who's here, who's advocating for their right to be here. Technically, they're not citizens. They're trying to involve themselves in the election. So if you're going to say those two things magically equal a crime, you've just criminalized something that, about 5 million people do here, who are some of the poorest and most vulnerable people in our population. And while I have conservative views in general on the rule of law as it relates to immigration, I don't want to see that happen. And I believe in First Amendment freedoms and don't like anything that restricts or restrains it. And so I think that's why they've stayed vague and called it abuse of power and not get into, okay, well, what law does it actually violate? Well, it's because it probably doesn't really violate any without getting into constitutionally protected territory.
Well, but the thinking I have on that is, hypothetically, if there is in fact something valid to investigate, although it may have an impact on Trump's personal interests, I don't understand how it is not by definition something of national interest. Just by definition, to investigate any political corruption would be of national interest, regardless of whether or not it benefits one party over the other, because it would in any political world.
In fact, the backstory they're not telling here, I remember when I first read the transcript, I understood exactly what happened, at least in that conversation, is Zelensky was trying to push whether or not Trump was going to clean up, in Zelensky's view, the U.S. side of the aisle when it came to corruption. Because what he's saying is, a lot of this stuff has been in your direction. He's saying it diplomatically, he's saying it indirectly. That's why you have to splice that conversation. But you look at what he's saying is, he says, thanks for all this. We really want to clean stuff up, and I'm going to need your assistance on it. And that's what he's talking about. So the reason is Ukraine has been a proxy between the U.S. and Russia for a long time. Both of our countries have frankly tried to corruptly interfere with their government for ever since the end of the Cold War. And Zelensky was elected to end that. No more Russian corruption, also no more U.S. corruption. And it's the backstory they're not telling. It was funny, their historical version where they really despise Poroshenko and really love Zelensky. And they know most Americans don't know anything about this, but that's entirely bogus. It's right in the transcript where Zelensky was going after Yovanovitch. He was like, he hated her for good cause. Yovanovitch helped put in Poroshenko. It was part of the Maidan Revolution, which was really a coup. People like Oliver Stone have done multiple films on this. Ukraine on Fire. People can look it up. It's just our involvement in Ukraine is not a pretty involvement. It's not about, unfortunately, not about promoting democracy and freedom and liberty. It's about a proxy war to control Russia's relationship to Europe. And we shouldn't have even been there in the first place. Down deep, I think that's the other reason this escalated. There are people in the intelligence national security apparatus who I believe really think Trump would rather just get the heck out of there altogether. And I think down deep, that's Trump's view. Trump's like, what? Because he's like a businessman, New York businessman. What are we getting out of this? They don't got no oil. They don't got this. Why are we there? Let's just pull out. Why am I supposed to be sending money to these people? I think that's the real reason why he got impeached, not so much his attempt to find out what they knew about Biden or for them to figure out what they knew about Biden. Though I'm sure he's not happy about what happened in 2016, obviously.
Yeah, very cool. Noreen, thank you very much for the super chat. I think I saw two more scrolling down. Oh, no, I think I just skipped over them. Hold on. We got one from Mark Mace. We got a few here. Okay. Sorry. Hold on. Oh, my goodness. Did I skip a bunch? I may have skipped. Did I read this? Little Schiffy says he'll ignore any Senate subpoena. That was one question I was asking. Can they subpoena Schiff? Glad I found this one right here. Little Schiffy says he'll ignore any Senate subpoena. Is there any legal situation more ironic than a man running impeachment of a president for questioning a subpoena himself? Questioning a subpoena. Jason L., thank you for the super chat. I'm going to take it down so we can actually see Robert here. Robert, can Schiff be compelled to testify?
Oh, absolutely. With ease. In fact, they could give the subpoena right on the Senate floor while he's there. So and he could, try to take it up and say, really, I'm participating in a legal proceeding, and so I should have legal proceeding immunity, though I can't be subpoenaed for another, but it's the same case. So it would be different. But I don't know if you've had this experience. I've had people try to subpoena me as the lawyer for a client. For various reasons. They usually back off, but it's usually a strategic tactic in the case. But in this case, I think there's no doubt they suspect there was basically a behind-the-scenes story where people were orchestrating things over the summer between Vindman, the whistleblower, and Schiff's team. And they have strong suspicions in that respect. And Schiff has enhanced those by classifying so much related to the whistleblower's lawyers being over the top about how there's magical anonymity now for every whistleblower in the world, when that only applies to a limited subset of officials. So my hunch is he would make a very interesting witness. Yes, they could subpoena him. Yes, they could politically embarrass him. It's why I think down deep, they don't actually want to get down this path of let's have everybody call whoever they wanted. I think they're hoping the Republicans reject their request for witnesses so they can use that against them politically. They're hoping it does not go down the path of each side getting whatever witness they want.
But they could, no, you can't subpoena someone at the courthouse. Could they subpoena Schiff at least you can't in Quebec, but could they subpoena Schiff on the Senate floor?
The same privilege exists generally. Like there's two privileges here that would be pertinent. Generally, you can't be subpoenaed for another trial if you're in one trial, but you can be subpoenaed for that trial if you show up. So that particular privilege in this case would not apply to him because he would be. So, for example, someone couldn't subpoena Schiff for another trial happening somewhere else in the country at the Senate hearing because he's participating in it. Right. But they could for the Senate trial. Now, there's a second privilege in the U.S. You can't be subpoenaed in the United States if you're part of your going back and forth to the House or the Senate. There's been different laws challenging different aspects. An old icon of mine, Huey Long, had a big legal battle about this. So he could argue that. He could argue that technically he's participating in Senate duty, and thus he's immune from a subpoena. But none of these arguments would look nice politically. For the same reason you're pointing out that the White House's argument isn't going to look great on subpoenas, that argument would even be worse coming from Schiff.
Okay. Very cool. Who do we got? We got Christine Hartloff. How can impeachment be permanently removed from Trump's record? Yeah. the impeachment can never be removed from his record. He will always be the third president to be impeached. He may just become, first of all, thank you very much for the super chat. He may just be the first president to be reelected after impeachment.
There's some argument that he can't run for election if he's impeached and removed. Back at the original time they passed impeachment, it was interpreted as a permanent ban on that office.
Impeached and removed. So the Senate if the Senate convicts, he can't run for office. That I think we all understand. Right. If the Senate quits, he never has that impeachment removed from his record. That's
true. Now, theoretically, the House could come in next term and expunge the impeachment if the Republicans win. In fact, if the House is smart, Republicans are smart, they'll run on that. They'll run on, we're going to expunge this horrendous record of attack on our good press. I think that would do so. If a court can expunge a prior conviction, why couldn't the House expunge a prior impeachment?
Interesting. While we're on the subject, I heard some discussion floating around that if he is impeached and acquitted, he can run for an additional term. Have you heard this?
This was a complicated interpretation that he would not have served the actual term. And so if for some reason, I think their theory at the time was there are people who thought that he could be convicted and still run for office, and that thus by not being able to having the opportunity to serve out his full term, he would be able to then serve another additional term. But I think that's based on a misinterpretation of whether or not he can actually run for office. It's not clear because the original interpretation of impeachment was removal prohibits you from running, but there was they didn't use that exact language in the Constitution. So there is an argument. It's just never been challenged. And clearly doesn't apply to all office because there's current congressmen sitting in the House who were impeached and removed when they were federal judges. I was hoping they were going to use him as the Democratic expert on impeachment, but I didn't get so lucky.
Very interesting. Okay, who do we got here? We got Andy Crahingen says, is there a precedent that would penalize the Democrats for bringing this impeachment should it be dismissed? Thank you for the super chat. Good question, Robert.
Nope. Just political punishment, obviously. Historical punishment, but no legal punishment.
Okay, interesting. We got Breton Thrasher. Chance that Sandmann equals confrontation at more rallies. Oh, I think everyone's going to have learned a lesson from Sandmann, but Robert, you may be more or less optimistic than me.
I mean, I think that, 2016, I interpret it as a Democratic tactic. Other people would have had other interpretations, but it seemed like confrontation at rallies was politically benefiting the left, so they gave them an incentive and a motivation to do it. It was because of how we handled, I think, legally the Sandmann from maybe the Covington kids, Lynn Wood on behalf of Nick Sandmann. The net effect of that, I think, has deterred that as a tactic, but it might come back. Street theater has been a politically trained tactic dating back to the 1400s. Peasant revolutions were a means of street theater. But particularly in the 1920s, 1930s, the communists and the fascists loved to get on the street and fight each other to vindicate their power publicly, was that the other side was worse than they were. And so your Antifa types, your alt-right types still believe in that. So I think that's the risk of constant street theater conflict or violence, is there are people out there that think it's a ticket to political power.
Very interesting. Okay, we got Mark Mace. What is the relationship with attorney-client privilege in a congressional subpoena context? Was Trump's sending Giuliani to Ukraine strategic?
So two different components there. There's attorney-client privilege between Trump and Giuliani, which completely applies. Then there's attorney-client privilege in the White House giving advice to the executive branch, and that gets very complicated because it's institutional attorney-client privilege, and the scope of it varies depending on the subject matter and the issue. I get what Trump was trying to do. He didn't trust everybody. He didn't trust anybody in his own State Department. This was partially his own fault for firing General Flynn. Flynn was bringing in a whole team that would have been loyal to Trump all across the board. That's the reason why they took out Flynn so fast, but they used Trump's own paranoia to do it. And so because of it, Trump got to the point where he saw everybody around him was an adversary. So he needed somebody that he could trust personally, that he thought was persuadable to the Ukrainians to get to the bottom of whatever was happening. I disagree with the Democrats that his real target or focal point was just Biden and just using it for political leverage. that aspect of it. I'm not saying he was doing it solely to investigate corruption. I think he had a personal curiosity as to how deep Ukraine was in 2016. Were they constantly opposed to them? Were they misappropriating funds? Were the people connected to Ukraine still connected to Christopher Steele and the oligarchs? People forget Ukraine sits at the center of all of that. Ukrainian oligarch was funding Christopher Steele, who was writing the Steele dossier, which was behind the Russiagate investigation, which led to Mueller. So that's why Trump connects all of this it goes back to Ukraine. And I think that's why that was the way it was. So I get why he was trying to use Giuliani. I was surprised at Giuliani's lack of political acumen, in my view. It shows he's been out of the game a little while. If people want to understand the legal system, I recommend they watch shows like Damages, shows like Billions, shows to some degree like Boston Legal, which are more fun. But those other two will show you how the legal system really operates at a high level, civilly and criminally. And you need Ray Donovan types on your staff effectively to figure out what's happening. Not recommending everything Ray Donovan does in the show, but I think Giuliani was so straight. Now it's part of his defense now. It's like how could really Giuliani be part of a secret private conspiracy when he was on Fox and Friends every other day telling people what he was doing? So that's it's a useful defense. But I think Giuliani could have been more sophisticated. I think he was a little bit out of his element, and it shows you how much Trump is isolated, that he doesn't have somebody inside the White House who could handle that for him. To say, hey, look, I don't know what's happening in Ukraine. I don't know what's happening with these people connected to Ukraine. There's certain things I want to find out, make sure I do it legally, make sure I do it correctly, but I want to get to the bottom of it. He had nobody around him who was actually doing that for him. So he had to reach out to Giuliani. So I think the idea was the right one. I think the execution is something that even Giuliani would say he would like to revisit.
Yeah. Okay. Very interesting. Okay. We got another one here. Beastifus. How can Trump be impeached for no actual crime when the Constitution states it requires high crimes and misdemeanors? Love you guys. Beastifus, thank you very much for the super chat. We dealt with this in detail, I think, at roughly 30 minutes to 1 hour of this live stream. So rewatch it. We'll get an extra view, but no, go back because we can't redo that whole conversation right now. We got Jamie. Thank you very much. Cool sunglasses emoji. Who else we got here? Okay, we got Fricky Ticky. If the Republicans take over the House next year, would they have the ability to censure or otherwise punish Pelosi, Nadler, and Schiff if reelected for how they've handled this?
They could do two different things. They could censor. Also, if they find certain violations that fit the Constitution, they could expel. I don't think expulsion has happened since Adam Clayton Powell, who I was actually a fan of. I liked Adam Clayton Powell. A little bit eclectic. He's portrayed well in the recent Godfather of Harlem TV series. So I like him. Old school guy. He drank bourbon with Big Jim Folsom down in Alabama in the 1940s. Great old populist governor of the state of Alabama. Who was for civil rights when it was very, very, very unpopular in Alabama. But yeah, those are their two remedies. So when people say, could they be impeached? That's not the internal remedy. The remedy is actually technically expulsion under the Constitution. And they could look up the U.S. Supreme Court case about what they can and cannot expel for. Just look up Powell expulsion U.S. Supreme Court, and it'll pop up on Google.
Amazing. Fricky Ticky, thank you very much for the super chat. Good question. We got one. Let's see. I saw something more down here. PSN guides. Couldn't the Senate have called any witnesses for the president while the House was denying them?
Oh, absolutely. And in fact, one of the complaints has been you have senators who are running for re-election, like Graham out of South Carolina, who has no real interest in promoting this aspect of the Trump's agenda, but he doesn't want anybody to challenge him in South Carolina in the Republican primary. So he pretends he's going to call witnesses and pretends he's going to investigate. Nothing ever happens. So he'll give aggressive interviews on Fox, and then he'll go back to doing nothing. So it's part of the whole Trumpian revolution was about a populist wing of the Republican Party in the United States that had been emerging over the past decade. But it has almost no representatives in either the House or the Senate. So it's why Trump is so isolated. And it has definitely no representatives in the institutional bureaucracy of the U.S. government at a high level. Definitely not with the national security apparatus or the rest, which are entrenched with people who have a fundamentally different opinion about what the policies of the country should be.
Yeah, I wonder how long it takes actually to reverse the direction of that massive ship. It'll take more than 4 years, that's for sure. PSA, thank you very much for the super chat. I know that I missed two more because I see them up there. Andrew Starr. Okay, we got PSN. Okay, here we go. So we got this. Robin and Robert, tell me we've been doing this for 2.25 hours. Do we cut it off in 18 minutes?
Yeah, sure. Whatever's good with your schedule is good by me.
Okay. Robin Bullock, can the Mitch McConnell obtain and release the phone records of Adam Schiff?
Yes, he can. My general view is not to retaliate in those manners. I don't like these invasive subpoenas that have been issued to people's private phone records that should have gone through a different process. It shows how accustomed they're used to doing it, because like almost a third of the evidence they were talking about today, when they mentioned phone calls, texts, and conversations of Rudy Giuliani and John Solomon and others, those were invasive subpoenas of private citizens that either implicated potential attorney-client communications or freedom of the press. And I don't know what they're thinking, because it's like, do they think that when Republicans get power, they're not going to return the favor? I think because they think Republicans have been more traditional in their approach and more respectful of the traditions, that they won't do so. A whole new wave of Republicans are coming to power. And when people like Matt Gaetz have a major role in the House, they're not going to be so self-restrictive when it comes to these techniques. But I wish there'd be fewer of these tactics rather than more.
Okay. Thank you very much, Robin, for the super chat. Andrew Starr says, thoughts on State Department and Civil Open Society 2.0. I don't even know what that question means.
It likely it could refer to two different things, but Open Society has connections to George Soros related entities that have supported different aspects of the State Department. The way in which private power and really foreign power works in DC, and it's fascinating that they're all of a sudden obsessed now in this impeachment with the influence of foreign governments. Well, if you go to Washington, both sides of the aisle, the number one thing everybody outside of government is doing is getting a paycheck from some foreign government. In fact, a lot of your so-called independent publications, independent broadcast, independent think tanks are mostly funded by foreign governments. They're the number one people funding. That's why you get there and you see all these seminar presentations on the schedule and on the calendar at almost every think tank for some esoteric conversation about the dispute between Qatar and Dubai. And you're like, why? Well, it turns out one party is funded by one and one party is funded by the other in our own capital. We're very much the Roman capital of the ancient Roman days. My old Yale professor, Paul Kennedy, predicted that very, very well, that we were becoming Rome. And so unfortunately, that's very commonplace. But so what she's talking about is an unfortunate problem that, Soros, through a variety of think tanks and foundations, can have influence with the State Department by hiring people as soon as they leave. It's the Washington's really created bribery in a sophisticated way. So it's not bribery because I've already left office when I get paid off, even though I knew when I was taking certain policy decisions while I was at the State Department or any other part of government that if I behaved a certain way, I was going to get rich when I walked out. It's a sad, unfortunate reality. But what she's talking about is ongoing. Like there's a suspicion that a lot of the people that attacked Trump in this group are going to end up working at think tanks funded by George Soros or other similar political activists who hate Trump. Okay. And then it's like, well, that sort of feels kind of like a witness getting bought off. That's the issue.
It's bribery in advance. It's bribery before the act, or rather the act before the payment.
Yes, post hoc bribery.
No, it's interesting. It was one of the issues that I had. It doesn't, not to pick on any politician in particular, but when former politicians are getting paid hundreds of thousands of dollars to give speeches, you sort of wonder, if that was in the back of their mind when they were making the decisions on behalf of the people who ultimately paid them this amount of money when they leave office.
You look at, I think America's general is a little tired of people getting riches by going through politics. It makes them doubt what happened while they were in office.
Absolutely. I mean, it's absolutely. Andrew, thank you very much for the super chat. James Johnson, if Trump survives this, can he choose the next Supreme Court justice to replace RBG?
He's definitely, in fact, it's one of the things that's holding the Republicans back. They don't want to lose presidential power. They know Trump is the key to their maintaining their presidential power, even if they don't personally like him. And they really want that next Supreme Court justice, along with the other judges that McConnell has pushed through. I mean, I think he's pushed through about 1/4 of the current federal judiciary is now Trump appointed. RGB, they're going to have to carry her out on a stretcher. I don't think she's going to leave the White House. She's not going to leave the Supreme Court while Donald Trump is in the White House. So I think she's made that clear. I mean, normally, I think if Hillary had won, RGB planned on retiring very quickly and letting Hillary, the first female president, replace her on the bench. Yeah. I think she was shocked that didn't happen. And so, but yes, the anticipation actually is that he will likely put 2, maybe even ultimately a total of 3 more, which would mean, like Nixon, he would have appointed a majority of the U.S. Supreme Court.
Fascinating. James Johnson, thanks a lot for the question. Thanks for the super chat. And I think there might have been one more scrolling down. We got, it skipped over it. No, there was one before Andrew Starr. There was Daniel. Sorry about this. Here we go. I scrolled to the bottom and I have to go back up. Second thing, James Trafficant was expelled from college.
He's right. I was thinking Adam Clayton Powell was the last. He's another one of my favorite congressmen. I like James. Yes, he did probably some things that were undesirable, but he was a very independent, eclectic voice. He was from Youngstown, and he was representing Youngstown when Youngstown was getting beat up, and Bruce Springsteen was singing about Youngstown, going down in Youngstown. But Trafficant did some things that were unfortunate that led him to be expelled from Congress. I don't think Rostenkowski was expelled. I think he resigned. He was another guy who got convicted of some various things from South Chicago.
Very interesting. Jason L., thank you very much for the super chat. Sakaki, you got Jason L. Could Republicans retroactively impeach Obama as payback? They can't retroactively impeach someone who's no longer in office, right? It's
actually an open question. So there's some legal theories out there that if you've ever been an official, you can be impeached for your prior acts,
so that you can never hold office ever again should you decide to rerun for something.
That's the interpretation. Okay. I personally don't think that's the case, or I don't think it should be the case. I don't think that's what the Constitution calls for. I also think it'd be a terrible precedent to set. I don't like impeachment power already, so I don't want to see it used more often in the future. If somebody did something really wrong, let the civil or criminal justice process take care of it.
All right. Thank you very much for the super chat, Jason. We got Daniel. There is no super chat, but thank you very much. No comments, I should say, but thank you for the super chat. Andrew Starr's got another one. Thank you, Robert. Plug all your social medias. Robert, plug it. We still got 1,321 people here. Everything you want to plug.
So you can always go to @Barnes_law on Twitter. You're going to have to actually find it because I'm shadow banned by every conceivable way by Twitter, who apparently, unfortunately, took objection to me suing them a couple of times. I'm also at BarnesLawLLP as in Peter.com. We're going to be putting up a lot more stuff there. So we're going to be putting up documents from the Covington case as they happen, so everybody can read the pleadings, read the responses, read each side's arguments, read the briefs, to try to create a sort of public repository, like a library or scholastic source of information where people can get, like from this channel, where they can get self-educated on the law and self-informed on the law, because that's a very important part of the little d democratic process of American law.
I was just talking about it with one of my brothers who's also a lawyer, that the system it's broken when people can't afford lawyers, and you get a different type of treatment when you don't have a lawyer. It's just
absolutely
fundamentally broken. Beastivist says even if they decided to have witnesses and brought in Hunter, they can't make him talk right. Yeah, he could plead the fifth all day long.
Yes, but that would be mighty interesting on the Senate floor. So I think Papa Joe ain't going to be happy with Hunter taking the fifth. Well, that will not be good.
Now that you mentioned he's being held in contempt, or at least being brought up on contempt in the paternity case, so I'm going to have to probably do a follow-up on that, because I've been following that as well with the order to be, that his financial documents should be filed under seal. Made an interesting video on that, so I'll have to follow up that as well. Mm-hmm. I think so then there's someone, let me see. Someone was talking about the FISA warrants. This was not the comment, but the FISA warrants were declared invalid on 2 of the 4 charges brought up on Carter Page, from what I just heard.
Yeah. And so the biggest impact of that is twofold. They said 2 were invalid, and the other 2 they wouldn't defend as valid. So, which is implicitly invalid. And the big question is, did they use any evidence for any case that derived from those FISA warrants, including cases we may have never heard about that may have led in totally different directions? Almost guaranteed that they did. So that's the big consequence up front. Like you may see Roger Stone bring motions on the grounds that evidence was produced or that led to him being investigated that derived from FISA. You'll probably see General Flynn added to his grounds that there was evidence that led to his inquiry from FISA that would not have occurred. And it's the old fruit of the poisonous tree. They have to argue that they never got close to that tree. No fruit ever produced from that tree that led to any investigation or inquiry or the chain of evidence. But my guess is there's a lot of other cases we don't know about, maybe a dozen, maybe 2 dozen smaller cases throughout the country that were not politicized, that this impacts and influences. It will definitely impact the Concord management case that's being prosecuted up in New York. That's the only real Mueller Russian prosecution case that's been very political and been very controversial now for about 2 years because the Concord management's very aggressive with what they seek in discovery. So it's going to have a lot of impacts. The second impact is Carter Page now has a factual finding and admission by the Department of Justice that they did not have probable cause to invade his privacy, which means he now probably has one of the easiest Bivens claims in history. And I've talked to Page a couple of times, met him in London, nice guy. I don't know how anybody could think that guy was a criminal. You could talk to him for 10 minutes and be like, no, okay. And the guy's he smiles way too much to be a criminal, first of all. But I am aware that he's planning on bringing exactly those lawsuits because it has not sat well with him what they did to him.
No, and it's amazing. The beautiful thing about the internet is that it democratizes information, and people have never been more informed. I know people say they've never been more ill-informed. I disagree with that because the truth does rise to the top, and you can sort of filter out the garbage. This is amazing. This is amazing that there are literally on a Thursday night 1,300 people learning about stuff that they would have never learned about otherwise, and that they will not learn about in standard mainstream media. No. Robert, you are a wealth of information. I'm absorbing a lot by osmosis, and it's fantastic. It's great. Josh, the cooking cop, says Robert is very smart. Can I shout out my Instagram, Cooking Cop 1? I love both of your point of views. This is real news. Will Trump be reelected? So first of all, I didn't actually see that comment when I said that we were, you won't get this stuff on the real news. Of course, you could shout out your IG channel, Cooking Cop 1, which I presume means you're a policeman who is cooking. Will Trump be reelected? What are the odds? I mean, are there odds now?
Oh yeah. So the betting markets have been around 40%. This tells you how bad impeachment was playing out. British betting markets, after impeachment, he went up to over 50%, the highest he's been since his original election. What I've told people is I've been on a buy Trump spree. So, one of my side businesses or side hobbies is political betting. Been doing it since I was a little kid. And so my advice to people has been to bet Trump until he hits about 80 or 85. I would personally put him around 90, 95 by historical metrics that I use to bet presidential elections. There are X factors. He's a total anomaly. There's never been anyone like him in the sense of no elected office background, and he continues to oppose the national security apparatus. And the people that have done that in the past have not been reelected or faced other issues. Nixon really arguably was impeached because he offended the corrupt Hoover wing of the FBI. When he tried to de-Hooverize the FBI, that's who became Deep Throat. The leader of Deep Throat was actually a guy who ran COINTELPRO and was one of the most corrupt FBI agents in history. That's probably part of the reason why Bob Woodward didn't tell everybody who he was, not just to protect his anonymity for democracy's purposes. I actually had that conversation with both Bob Woodward and Ben Bradley about a decade or so ago. But so the nature of it, I think he's almost a lock. The Democrats are looking like they're going to nominate someone that is driven by their opposition to Trump rather than the person they like the most. Complete failure of gubernatorial candidates to take off. None of the candidates anybody looks at, even Van Jones on CNN was saying, wow, none of these guys are going to win in the debate. Joe Biden went nuts on a reporter yesterday. His latest eclectic. Well, everybody calls it senior moments. So I guess that's I don't know if it's definitely not the politically correct terminology. Maybe it's the nice one.
I didn't consider it a senior moment. It's one of those moments where you just lose it because you just have people breathing down your neck all day, and it's like a momentary lapse of judgment. I mean, I don't judge him hard for it. I just think I don't know how it doesn't happen more often, but that's what being in politics is about.
You see why they try to control him so much. They realize his ability to, like in the old day, this is a guy who's been through so much. Usually he could control his temper easily. He could everything just sort of brushed off of him. But it has not gone that way this past year. So and I'll give Bernie credit. He had somebody put out a hit on him and say, hey, Biden's corrupt. And at the same time, came out with a very effective political ad that said, by the way, Joe wants to cut your Social Security, when 2/3 of Joe Biden's supporters are over 65. And then Bernie said, "Oh, I'm so sorry about calling you corrupt, but we're going to still keep running that Social Security ad." And that was the context in which Biden lost it. So he was like, Bernie got away with one where I can't really hit Bernie for really hitting me because he backed off of the other slanderous charge during the impeachment proceedings. He also, I'm sure Biden is not thrilled with his name getting mentioned every other minute by the Democrats on the House floor in the impeachment chambers, saying, "Don't worry, he wasn't really corrupt. He needed to fire that guy." That's not what he wanted a week before Iowa.
That's I absolutely. Incidentally, when you're betting on Trump now, and you say it's 50%, are you buying stock so you can sort of buy it at 50% and sell it at 85 if it ever gets there?
Yeah, absolutely. Because so way that works is in the UK is the premium betting markets in the world. There's only a small betting market here in the United States on Predicted, which was set up by a lefty professor I debate occasionally online, but a very smart guy, David Rothschild. And so the Betfair is like a stock market. So basically, you go in and say, "I'm going to bid, say Biden at 25, which is basically translates to percentage." And somebody maybe says, "Well, I'll sell them. I'll buy it for 23." So you have literally buy sells of actual stocks in candidates on an open public market, and you have betting sports books where you're locked into your bet. But 95% of your betting takes place on what's called with Betfair, which is a public betting exchange. So you can go in and out. So I've been giving people advice over the whole summer. If people have been following my advice, they've been making some serious cash. And I know some people in the UK that have made six figures just following free recommendations I've given to the public because the Democrats Bernie Sanders was trading at 7% at one point. Joe Biden was trading at 10% at one point. That never made sense. Elizabeth Warren was too high. She was at 40% at one point. Kamala Harris was at 40% at one point. Those were both too high. So there's a profitable opportunity. And political betting is probably coming to the United States in 5 to 10 years as sports betting gets more widely legalized across the country. Political betting will likely follow it. We're not going to sit around, and the U.S. is not going to sit around and watch the UK get all the cash for bet on U.S. elections.
If the government can make money off of it, they're not going to say no.
Exactly.
Okay, we got Bam Bam Niner says, "What are the next steps if Trump is somehow found guilty by the Senate? Is he removed immediately?" Thanks for
there are interesting issues about that. So let's say my guess is Trump will not step down. So if that happened, I think Trump will challenge it with the courts and will seek an injunction saying it should be stayed pending a court adjudication about whether these were impeachable charges, so on and so forth. It's never really got to that stage. By the way, there was a judge who's also named Nixon, by the way. So there's a famous impeachment case called United States v. Nixon, and who refused to step down after he was removed. In fact, he was in prison and he was still acting like he was a judge. So he was insistent. He was one of the people to argue about whether the Senate had to have witnesses at a trial, and that's what the Supreme Court said. How the Senate handles a trial is totally up to the Senate, which has sometimes been misinterpreted to mean the Supreme Court has no power over impeachment at all. But the expulsion cases would say the opposite. It's just they have a power over certain areas, not over others. But my guess is Trump would challenge it, contest it, run it up the flagpole, and we would have maybe a real constitutional crisis in the country. And the Supreme Court would probably have to resolve it. They would also probably be watching the political reaction. I think you would see real people in the streets that would make the Tea Party look like a small cocktail party get together. They'll be unleashing a political force that already doesn't believe in the government, really. And do they really want those people out in the streets because they think they have no power left and they think their vote doesn't matter anymore? This is like the mistake the left made about Brexit in the UK. By not honoring it, they killed themselves over time politically. And it's probably going to be a generation, at least a decade, before they get political power back, when they were on the cusp of it right after Brexit. So I think it's the same dynamic. So but it'd be interesting times. I'll put it that way.
It'll be probably more interesting to be observing from Canada.
Yes, no doubt.
Okay, we're gonna wrap it up like within the next 2 minutes here. Let's see. Hermit says, Hermit Leon, thank you very much for the super chat. If one was interested in law school, what undergraduate degree do y'all suggest? I'm partial to philosophy or political science.
I would say analytic philosophy, particularly my brother's an analytical philosophy professor. So in the US, there's a lot of what's loosely called continental philosophy. And the nature of it doesn't tend to be rigorous in its thinking. It doesn't require that as part of its disciplinary methodology. It's more from the sort of Foucault school of thought, which has utility to it, but it's not so applicable to legal reasoning. Analytic philosophy of the kind my brother teaches would be very, very influential. The others I highly recommend because I like it, history. Because a lot of what you really do as a lawyer is you study the past. You study the past in cases. You study the past in trial techniques. You study the past in deposition testimony before a trial. You study the past to predict and forecast the future and to understand the best way to interface with it. And as Shakespeare said, past is prologue. So I think there is utility and applicability in history to a legal degree.
Yeah, I would say one of the ones I sort of regret not having gotten would be an MBA, because having an understanding of business, especially in commercial litigation, if you're dealing with commercial litigation and you don't know how to read a financial statement or a profit and loss statement, it makes it a little difficult to properly represent the client, and it's a learning curve.
No doubt about that. So many people have no clue. There's a guy who became famous in Sweden. It was recently on Dave Rubin, solely because he was explaining to the Swedish population the very basic understanding of financial statement related issues related to the government. And I was like fascinated. I was like, that was really that radical for people in Sweden? But it showed, there's no doubt about it. There's the basics of it. You get into this guy, in particular, you start talking about derivative litigation. That's stuff that most people who are everyday stockholders in businesses do not understand their own legal rights and remedies.
All right. And we're getting actually fuzzy. So this might be the perfect time. There's one more super chat right here. Just wanted to say, I love your channel and approach to free speech. Just a normal bottle of mustard. Thank you very much for the super chat. Possibly the weirdest username and avatar I've ever seen, but thank you very much. And I mean, look, it's the most important thing in the world, because the free exchange of ideas allows people to test, challenge, and validate. And without it, shutting down speech doesn't do anything to build anything.
Exactly.
Robert, you and I will stick around for 2 minutes after this. Everyone, thank you very much for tuning in. This was fantastic, phenomenal, informative for me. Robert didn't have any of the questions that I was going to ask him. I gave him like 5 topics that we wanted to cover just because I knew everybody was going to want to talk about it. But I learned a ton. I'm going to have to rewatch this live stream and redigest some of the history, because fascinating. Okay, everyone. So that's it. Thank you very much for coming. I will see you guys tomorrow in my next vlog. Saturday night, I'm doing a live stream with Body Language Ghost, which is going to be fantastic also. So everyone, thank you for tuning in. It was great. Robert, stick around. We're going to talk afterwards, and peace out, everybody, and broadcast.